the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable, the Supreme Court of the Philippines shall give their attention. For the court is now in session.
The clerk of court will please call the case.
Called for today's oral arguments is the case of GR number 205825, the Diocese of Bacolod, represented by the Most Reverend Bishop Vicente M. Navarra and the Bishop himself in his personal capacity, versus the Commission on Elections and the Election Officer of Bacolod City, Attorney Mavil Maharucon Sia. Appearing as counsels for petitioners are the following: Attorney Ralph A. Sarmiento, Attorney Raimundo T. Pandan Jr., and Attorney Michelle Abelia. Arguing for the petitioners are Attorney Ralph Sarmiento, who will argue for 14 minutes, while Attorney Raimundo T. Pandan Jr. will argue for 6 minutes. Appearing for the respondents is the Office of the Solicitor General, by the Solicitor General himself, Francis H. Hardilesa, Assistant Solicitor General Vida G. San Vicente, State Solicitor Marie Christine R. Nolasco Jimenez, Associate Solicitor Dexter Matias, and Associate Solicitor Romeo O. Caboteja, Jr. Arguing for the respondent is the Solicitor General, Francis H. Hardilesa.
The counsel for both parties will please confirm you've received your advisory and will be guided thereby. Counsel for petitioners can commence.
On the part of the counsel for petitioners, yes, Your Honor, we received our advisory.
Please proceed.
Madam Chief Justice, Your Honors, good afternoon, and may it please the Court. The Team Buhay, Team Patay Tarpaulin of the Diocese of Bacolod is posted for the sole purpose of communicating the message of the diocese concerning the reproductive health law, for the RH law.
Counsel, can you please turn on your microphone? Okay.
Your Honors, the respondent's order for the immediate removal of the said tarpaulin, coupled with a threat of subsequent punishment, is a violation of the right of the diocese to get its message across, and therefore an infringement and a prior restraint of its right to freedom of expression. I will handle the first three issues, Your Honor, based on the advisory, dealing with jurisdictional issues and the issue of freedom of expression, while my co-counsel, Attorney Raimundo T. Pandan Jr., Your Honor, will handle the last two issues dealing with the principle of separation of church and state. On the first issue, Your Honors, it is petitioners' humble submission that there are exceptional and compelling reasons which would justify a direct resort to this honorable court by way of exception to the doctrine of hierarchy of courts. Let me enumerate the said reasons, Your Honor. First reason, Your Honor, the petition raises genuine issues of constitutionality, which must be settled early, given the far-reaching implications of the unconstitutional acts of the respondents, which bears a serious consequence on the freedom of expression and on the principle of separation of church and state. Second, Your Honor, the issues involved are matters of transcendental importance to the public. Considering that the standoff between the Diocese of Bacolod and the Comelec has already sparked national interest, given the magnitude of the problem created by the unconstitutional acts of the respondent, Comelec. Third, Your Honors, this is a case of first impression, and there is as yet no local jurisprudence yet which would guide the lower courts on this particular issue. And therefore, had we passed through the lower courts, it would have been an exercise in futility. Fourth, Your Honors, the constitutional issues raised are better decided by this honorable court. In the case of Drilon versus Lim, which involves a question a challenge on the constitutionality of a law that was filed before a lower court. This honorable court held that it will be more prudent for a lower court to defer to the higher judgment of this honorable court, if only out of becoming modesty, because this honorable court is more equipped to deal with constitutional issues which must be settled after a thorough deliberation that can only be done by a collegial body like this honorable court. And fifth, Your Honors, settling this controversy between the respondent, Comelec, and the Diocese of Bacolod is not only a matter of right, but also a matter of duty on the part of this honorable court. In the case of Liga ng mga Barangay National versus Atienza, this honorable court ruled that when an act of the legislative department and that of the office of the president is seriously challenged on the ground that it infringed on basic freedoms and preferred rights under the Bill of Rights, it becomes a duty on the part of this honorable court to settle the controversy. And by way of analogy, Your Honors, we submit that the same should also apply to the acts of an independent constitutional commission like the respondent Comelec. And therefore, with that, Your Honor, with the enumeration of the 5 reasons, we submit, Your Honor, that this honorable court should not hesitate to relax the rule on hierarchy of courts, Your Honor, and to take cognizance of this case, and to exercise its primary and regional jurisdiction, which is concurrent with other lower courts. Now, on the second issue, Your Honors, our submission is that it is no longer relevant to determine whether the subject tarpaulin is an election campaign material or a political advertisement. Because either way, Your Honor, it will be protected by the Bill of Rights. Your Honors, the subject tarpaulin, our contention is that it is not an election campaign propaganda material. The posting of the mention of names, in particular, Your Honor, as enumerated in the subject tarpaulin, is only part of the campaign of the Diocese of Bacolod concerning the RH law. The enumeration was simply based on who supported or who opposed the reproductive health law when it was still being deliberated in Congress. But even assuming, Your Honors, that it is an election campaign propaganda material, it would still be protected by the Bill of Rights as part of the prerogative or right of an individual exercising his freedom of expression within the premises of his private property to express his preference of candidates in the coming May 13, 2013 elections, and then to convince others to follow his thoughts on the particular matter. And therefore, Your Honors, it is our submission that whether the subject tarpaulin is an election campaign propaganda material or not is no longer material, nor no longer relevant in a matter at hand, considering that either way, it would still be protected by the Bill of Rights. On the third issue, Your Honors, it is our humble submission that the subject tarpaulin is a form of expression protected by the Bill of Rights. For almost 2 years now, Your Honors, the petitioners, the bishop, and the Diocese of Bacolod have stood firm on their campaign and advocacy against the RH law. The subject tarpaulin, Your Honor, is part of that campaign and advocacy. It contains a message, a thought, and an idea. And when that idea is written, printed on tarpaulin, and communicated through that medium, such medium becomes a constitutionally protected mode of expression protected by the Bill of Rights. The message contained in the subject tarpaulin, moreover, Your Honor, is a matter it's a matter of public concern. It is a non-commercial speech which actually deserves more protection as compared to other forms of speech. And in the hierarchy of constitutional values, it deserves more protection as compared to other forms of speech. And besides, Your Honor, speech actually serves one of its greatest purposes in the context of elections, when the free exercise thereof informs the people what the issues are, who are supporting what issues, because democracy, Your Honor, is based on the right of the people to know, and on the right of advocates to make known to the people what the people need to know, so that the people can make their own independent judgment and choices based on matters that are important to them. In Andiong versus Comelec, Your Honors, this honorable court ruled that the preferred freedom of expression calls all the more for utmost respect when what may be curtailed is the dissemination of information to make more meaningful the equally vital right of suffrage. Your Honors, on the sub-issue of whether the Comelec has the authority to regulate this particular form of expression, our answer is, insofar as it is being applied on the Bishop of Bacolod, who is neither a candidate nor a member of any political party, and who merely exercises his freedom of expression within the premises of private property, Your Honor, we submit that the Comelec does not have the authority to regulate this particular form of expression. And in fact, the Constitution and the law have not given the Comelec such power or authority. In Sanidad versus Comelec, this Honorable Court has clarified that it is clear from Article 9, subparagraph C of the 1987 Constitution that what was granted to Comelec was merely the right or the power to supervise and to regulate the enjoyment, regulate the use and enjoyment of franchises, permits, and other grants for the operation of transportation and other media of communication and information. The Comelec, Your Honors, was never given the authority to regulate the exercise of freedom of expression by individuals, especially when they are merely exercising the same within the premises of their private property, Your Honors. In fact, Your Honors, this is perhaps the reason why Section 9 of Republic Act number 9006 of the Fair Election Act only mentions candidates. It never mentions, it doesn't say all persons or any person, whether a candidate or not, but it simply says candidates. And in fact, the same is also true with Section 17 of Comelec Resolution number 9615, which implements the Fair Election Act in relation to the May 13, 2013 election. The said Comelec resolution, which was promulgated on January 15 of this year, 2013, also says parties and candidates, not any or all persons. It only says parties and candidates may post election campaign propaganda materials in private places, provided they have the consent of the owner thereof. That is all that election laws are saying about this thing, Your Honor, in particular about the posting of election propaganda material in private places. It merely says it allows, or that parties and candidates are allowed to post election campaign material on private places, provided they have the consent of the owner thereof. Had the intention of the law been to cover all persons, then the provisions of the Fair Election Act should have been worded to say any person, whether or not a voter or whether or not a candidate, may post election campaign propaganda materials in private places. But that is not the language. That is the same language in Republic Act number 4880, which was the subject of this case, the case of Gonzales versus Comelec. But this is not the language of the Fair Election Act. This is not the language of Comelec Resolution number 9619. In this case, Your Honor, the message and the tarpaulin did not come from any candidate or political party. The message itself, Your Honors, came from the diocese itself. The tarpaulin is a property owned by the diocese. The place where the tarpaulin was posted is a private property owned by the diocese. And in fact, Your Honors, it's not only the message and the expression of that message which are protected by the Bill of Rights. The tarpaulin itself, Your Honors, the physical tarpaulin itself, is a private property protected by the Bill of Rights. And as the owner of the property, Your Honor, the Diocese of Bacolod cannot be deprived thereof or of its use except in cases permissible by the Constitution, which in this case, Your Honor, is absent. And on the sub-issue, Your Honor, of whether this particular form of expression can be regulated, our answer is yes, of course, Your Honor, provided, of course, that the resolution, any regulation affecting this particular form of expression should be reasonable, it should not be arbitrary, and it must be within the power of the state to promulgate. In Gitlow versus New York, Your Honors, while it was acknowledged that the liberty of expression is not absolute, the court ruled it may be restrained only in instances where its exercise bears a causal relation with some substantive evil, either consummated, attempted, or likely. And in fact, in the case of Adiong versus Comelec, this honorable court ruled that under the clear and present danger rule, not only must the danger be patently clear and pressingly present, but the evil sought to be avoided must also be substantive as to justify a repression of free speech. In this case, Your Honors, there is no compelling or substantial state interest that is endangered or which will be endangered by the posting of the subject tarpaulin, which would justify an infringement of freedom of expression. Even the Comelec's mandate to ensure free, honest, orderly, and peaceful elections, Your Honor, is neither compelling nor substantial enough to repress or to restrain the exercise of freedom of expression. Your Honors, the freedom to speak freely and to express one's thoughts about matters of public concern is the essence and the keystone of democracy. And in fact, its protection is the surest guarantee against the destruction of all other freedoms. And so, Your Honors, any regulation or order that restrains the exercise of free expression or destroy its effective exercise should therefore be slaughtered in the altar of constitutionalism. Having said that, Your Honors, I am now ready to assist this court in your clarificatory questions. May it please the court.
Justice Leonel.
I think there's one more counsel, Your Honor. If it will be all right with the court to finish the petitioners.
Okay. Next counsel, please.
Okay, Your Honor. May I cede the podium to our second counsel, Your Honor, Attorney Pandan.
Where belief and conscience speak, the state must keep an open mind, even offer a helping hand. Madam Chief Justice, Your Honors, may it please the court. The arguments on separation of church and state flow from the argument on freedom of speech. Understandably so, because nowhere is speech more important than in the exercise of religious freedom. For at the very heart of religious belief, creed, and worship are words, the holiest words. Thus, this court has accorded the highest degree of protection to religious speech, second only to religious belief. It is no accident, then, that the two preferred guarantees of freedom and religion under our Constitution have their source from but one amendment to the United States Constitution. Here, then, is a case that involves the weaving of both freedoms. In the expression here, one can scarcely separate religious freedom from free speech. In this novel case, the state, through its agent, seeks to silence the right of the Diocese of Bacolod and its bishop to speak to the faithful on a matter of religious doctrine. The state may well believe that there is enough compelling interest in limiting the size of the questioned poster, as they may impact on fairness and equality in the right to vote, enough perhaps to overcome the overwhelming constitutional mandate in favor of religion. We believe not, Your Honors. Time and time again, the state has been given the burden of proving compelling interest enough to override the constitutional guarantee of religious liberty. It has rarely, if ever, proven such compelling interest. While there has been no case of similar import in the Philippines, the eminent constitutionalist Bernas has said that not even protecting the right to vote is compelling enough to curtail religion. He has said that the duty to register and vote is not as compelling as the duty to defend the state, nor is it as ancient as religious freedom. Hence, in the hierarchical balancing of values, the duty to vote, when that is constitutionally imposed, may well be made to yield to free exercise of religion. The command of God is more terrible than the appeal to vote. The power which impels one to believe is greater than that which calls one to vote. Religion is a matter of life and death. Voting is not. In its comment, the respondents would have this court pay scant attention to these claims of religious liberty, dismissing its expression as a matter not of ecclesiastical character. But this is indeed an ecclesiastical matter. The lesson in Ibralinag versus School Superintendent is clear. Whose viewpoint prevails when the state claims it is not religious and adherents claim it is? In Ibralinag, this court has emphatically said that it should be the adherents. In concurrence, Justice Cruz pointed out in that case the state's erroneous assumption that it had the right to determine what was religious and what was not, and to dictate to the individual what he could and could not worship. The state is not one to hire its own government theologian to dispute each and every particular religious claim. So long as the bishop and the diocese sincerely believe the posting of the poster to be a religious matter, then it should be treated as such. One does not post trifling matters on a church wall. Here a higher authority commands, does one desecrate a holy place. That this expression is an ecclesiastical matter is further proven by church doctrine. In the encyclical Evangelium Vitae and in the Familiaris Consortio, the Church makes clear its advocacy of the gospel of life and its opposition to the RH law. As a matter of doctrine and faith, the Church says yes to life and no to the culture of death. This is the subject of the poster. The petitioners face punishment, especially the bishop for his act of speaking out in his faith. The Bishop of Bacolod, a soft-spoken 70-year-old prelate, is being threatened with an election offense. Here we are brought upon this unlikely arena where the state appears to be the church adversary. That has never been the case. The church has always benevolently and avidly cooperated with the state in the area of human rights, social service, labor, fair and honest elections. Where would this country be had not those priests and nuns not stared down the guns in the glorious days of peaceful revolution? Did not the church and its loyal, patriotic churchmen come to the aid of the state in those perilous days? Closer to home, and as we speak, just a few meters from Bacolod San Sebastian Cathedral, church property is being used as poster area by the Comelec at no cost to the government. Did the petitioner violate the Constitution by putting up the Team Patay, Team Buhay poster? We pray not, Your Honors. The phrase, separation of church and state, was first famously used by Thomas Jefferson in his letter to the Baptists of Danbury, Connecticut. This became part of the landmark Reynolds versus U.S. case. Jefferson said, I contemplate with sovereign reverence that act of the whole American people which declared that the legislature should make no law respecting an establishment of religion or prohibiting the free exercise, therefore, thus building a wall of separation between church and state. The antecedent, make no law, clearly shows that the constitutional stricture is directed against the state and not against the church. In light of recent jurisprudence, this court has made it clear that this provision is intended to keep the state out, not to wall the church in. Ours is still a nation under God, not above or without Him. The Catholic Church is loath to clash with government. That is not in its DNA. It is a peaceable faith. With the Lenten season upon us, it more than ever preaches its creed of tolerance and reconciliation. But religious freedom and freedom of speech are paramount considerations. And while the Church seeks reconciliation, it will not barter away its voice. For without words, and if the Church falls silent, it will have lost its great and ancient birthright and its right to exist as Holy Church. Seeing how crucial this voice is to the Church, as to all religious faiths, we pray this court to set the course in the direction of tolerance so that peaceable man may worship as his conscience dictates. Thank you, Your Honors.
May we hear from the third speaker from the...
If Your Honor, please, there are only two speakers.
Okay. Mrs. Leonen.
Thank you, Madam Chief Justice. May I direct my first questions to the counsel now on the podium and then later to the first counsel. Counsel, are the tarpaulins also posted in all dioceses in this republic?
So far as we could tell, Your Honor, it is posted only in Bacolod, but there are some dioceses. I don't know the breadth and
in the
length
Catholic
of the...
diocese, for instance, of Manila, are the tarpaulins posted?
I am not aware of that, Your Honor.
And we do believe that the Catholic Diocese of Manila also has the same papal encyclicals and the Bible guiding them. Is that not correct?
That's actually true, Your Honor.
Yet the tarpaulins of Team Patay, Team Buhay are not posted.
Well, if Your Honor, please, Mr. Justice Leonen, based on canonical provisions, the bishop is supreme in his own sphere. So insofar as the bishop
in
of
other
Bacolod
words,
is concerned...
the words Team Patay and then the listing of candidates and Team Buhay and the listing of candidates is not from, it does not draw its strength from the infallibility of the Pope of the Catholic Church.
Your Honor, that is true, Your Honor.
Yes,
we are not claiming
means,
dogma
therefore,
insofar as this
there
case is
is
concerned.
a human intervention here, perhaps even the political intervention of a bishop. Is that not correct?
If Your Honor, please, this is also based on certain encyclicals. For example, the Evangelium Vitae, which I
What
cited.
encyclical has Team Patay and then the listing of candidates, and Team Buhay, the listing of candidates?
There is none, Your Honor.
Thank you. With respect to the concept of death, for that matter, you said Team Patay refers to those that have produced the reproductive health law. Is that not correct?
Yeah, that's true, Your Honor.
Yet in the religion of Catholics, in our religion as Catholics, death is something that we value. As a matter of fact, we're about to celebrate Good Friday. Is that not correct?
Yes, Your Honor, that is
And
true
that
also.
it is the suffering of Jesus Christ. And
Yes,
in
that
fact,
is true,
his
Your Honor.
crucifixion.
If Your Honor, please, if I could explain, for instance, in the Evangelium Vitae, number 12, this particular encyclical by John Paul II speaks about the culture of death, not necessarily death, Your Honor. So we believe that insofar as the arch law is concerned, it speaks of the culture of death. So there's a difference, Your Honor, between the Catholic faith insofar as it's how it sees life.
I mean that the diocese has caricaturized several individuals and actually made a stereotype of them, telling the whole world that they have nothing except death.
I beg to disagree, Your Honor. The word caricaturize is...
Yes, Team Patay, then the listing of candidates, right? There is no qualification. Therefore, all of them belong to the team of death.
In that
Therefore,
sense, Your Honor.
they have
Insofar as
no-
the culture of death is concerned, Your Honor.
They have no redeeming value.
I don't know, Your Honor, insofar as that is concerned.
Isn't this a bit unchristian in terms of the Catholic Church?
Well, there have been some who have said this is unchristian, Your Honor.
And therefore, it is not really conclusively a belief of the Catholic Church in the Republic that we should have Team Patay, Team Buhay, tarpaulins.
Again, if Your Honor, please, the Bishop of Bacolod is limited only to his sphere insofar as he is concerned.
No, my question is with respect to the entire religion of Catholicism in the country. Is it a doctrine now of the Catholic Church that there should be tarpaulins which contains Team Patay and Team Buhay?
Not in that sense, Your Honor. But again, if Your Honor, please...
So do you still believe that there is your right to religion or freedom of
Yes, Your Honor.
religious worship?
Insofar as the Bishop of Bacolod is concerned, he takes guidance from several pronouncements, especially the Evangelium Vitae, which was written by Pope John Paul II. This is encyclical. And another one, Your Honor, the Familiaris Consortio, which is an apostolic exhortation again of
Again, Council, is
John
Team
Paul
Patay
II.
and Team Buhay in the papal encyclicals? Because
Not
I've
Your
also
Honor.
read them.
If Your Honor, please, insofar as it's concerned, we're talking about the expression itself. The expression of what is contained in the encyclical and the exhortation itself. Insofar as the bishop sees the encyclical and the exhortation. If Your Honor, please,
May I just clarify another point, because I think we got your answer to that question. It is not for this court to question whether Team Patay, listing of candidates, or Team Buhay, listing of candidates, is ecclesiastical or secular in nature. We have no competence to actually determine once a bishop says that it is religious. This court does not have jurisdiction to say that it is a secular political matter.
that seems to be the line of cases insofar as the case are concerned. As I've mentioned in the case of Ibralinag, citing Justice Cruz, in the case of Seeger, for example, the United States Supreme Court has said that weight must be given to the claims of the individuals in determining whether their beliefs are religious. The individual conscience becomes paramount.
Weight, of course, does not mean that it's an absolute proposition that the court of the Republic of the Philippines loses jurisdiction to characterize a physical act just because a bishop or an archbishop at that would have characterized the act as religion.
That is true, Your Honor, because in certain cases also, insofar as the Supreme Court is concerned, particularly in Soriano versus LaGuardia, the Supreme Court did actually say that a particular expression is not religious anymore.
Which was, of course, a divided court, correct?
Yes, of course, Your Honor. But going forward, insofar as the U.S. Supreme Court is concerned, in Ballard versus United States versus Ballard, Your Honor, the Supreme Court has said that a man who believed God has spoken to him to solicit money could not be made liable for fraud. Even this claim, the court said, could not make his religious belief speak a falsehood. So even in extreme cases, the US Supreme Court has allowed a flowing forth of a religious belief insofar as an individual's belief is concerned, Your Honor.
By the way, is the size of the tarpaulin also part of the encyclicals that you mentioned?
Not, again, there is nothing in those encyclicals that speak about the size of the tarpaulin.
So it could be...
In fact, there is nothing about those encyclicals that speak about tarpaulin. However, Your Honor...
So if the Comelec simply says that you can make the speech, you can broadcast whatever it is that you want to broadcast in relation to the elections or has a tangential effect on the elections, for so long as it is within a particular size, that does not infringe upon any religious freedom, because you just said that it is not part of the encyclical.
It's not part of the encyclical insofar as the exact physical nature of the tarpaulin is concerned. But again, as I mentioned, this is an expression. This is how the bishop sees these encyclicals. Even under canon law, for example, Your Honor, under canon law 747, it says it is the obligation and inherent right of the church, independent of any human authority, to preach the gospel to all peoples, using for this purpose even its own means of social communication. For it is the church that Christ the Lord entrusted the deposit of faith, that by assistance of the Holy Spirit it might conscientiously guard revealed truth, more intimately penetrate it, and faithfully proclaim and expound it.
Wait a minute, counsel. We're straying into another matter. Is your client being threatened with prosecution because of the opinion being expressed, or only because of the size of the tarpaulin?
Insofar as that is concerned, Your Honor, it's only the size of the...
So this is not like the Inquisition in the Middle Ages?
Of course, Your Honor. We are far from the Inquisition, Your Honor.
Yes, far from the Inquisition.
Yes, Your Honor.
And according to the comment which you might have with you, the comment of the government on behalf of Comelec, that what they simply want to regulate is simply the size. You can speak about Team Patay and Team Buhay, notwithstanding the fact that this does not appear to be in the Bible or in the encyclicals, for so long as the size is regulated.
If Your Honor, please, we believe that even the size, the prominence of the poster itself, and the fact that it is posted on the church wall, speaks an eloquence by itself. In other words, Your Honor, the reason why it is posted on the church wall is also part of the expression, and the fact that it's a particular size. If Your Honor, please, we did check
So Comelec does not want it posted on church walls?
Not necessarily, Your Honor.
So it is only the size?
If Your Honor, please, insofar as the expression is concerned, Your Honor, we did measure the size of the tarpaulin and also the distance of the tarpaulin from the sidewalk where the cathedral is placed and all the way up to the street. And the fact, Your Honor, is if that is limited only to 2 by 3, Your Honor, that is hardly visible to anybody who wants to see it. The reason why the church took upon itself to put up these posters is for a given reason. And the reason is to make it more visible to the people who need to see it. And also because, if Your Honor, please, the making of posters is by far cheaper than any other form of communication. And the church is trying to also send a message insofar as posting the posters are concerned, Your Honor.
Maybe one last question from me, counsel. Is it posted on private property?
Yes, Your Honor. It is posted on private property.
You mean nobody else can enter the premises?
That is not true, Your Honor. It doesn't mean necessarily that if property is private property, nobody can enter it. Insofar as restaurants, for example, are concerned.
In other words, it's posted in a church?
It is posted on the church wall, Your Honor.
Where the public can enter?
Yes, the public can enter the church.
Is there a limitation on the public that can enter? Can non-Catholics enter the premises?
Yes, Your Honor. Anybody can enter.
In the area, there are merchants, correct?
Yes, in front of the church there are merchants.
So this is not exactly a case similar to posting a poster inside one's home, to be seen only by visitors controlled by the owner. This is a case where the poster or the tarpaulin is in a public place.
It is in a public place, but it's still private property, if Your Honor, please.
Why can't Comelec, in the spirit of equal opportunity of candidates, Because, of course, you know that the church has a very loud voice, especially if it is the voice of the bishop of the diocese concerned, in the spirit of fair play, which is, I think, part of a Christian doctrine.
If Your Honor, please, I don't know what Your Honor means by a loud voice. The church tries to speak as softly as it can, especially our bishop.
If the church is able to reach more individuals than any other organization for that matter, then why is it that the Diocese of Bacolod seems to be insisting on gigantic size posters when it can just make the same language, make the same expression on smaller tarpaulins?
In fact, again, I've answered that question already, Your Honor. The size itself is part of the expression. And as I've said, the prominence of the sign has an eloquence by itself. It speaks of something about how the church sees the RH law and how the church stands insofar as the RH law is concerned, Your Honor.
Last question, did any candidate sponsor the tarpaulins?
So far as I could tell, Your Honor, none.
Is the church open to being audited by the Comelec just to make sure that this is not really funded by any candidate?
Of course, Your Honor.
And you are allowing intrusion by the church, by the state?
I don't know what I'm sorry, I'm not familiar with auditing rules, whether the COA can actually audit church property. But
no, not COA, Comelec, because Comelec is supposed to be in charge of looking at, according to your presentation, whether candidates are following the rules. And more often than not, candidates use the familiar term, donated by the friends of.
If you're
in this particular case, since you claim that this is not election propaganda, are you open for the Comelec to actually audit the expenses of the diocese with respect to the tarpaulins?
Again, if Your Honor, please, I'm not familiar with how the church runs its finances, Your Honor. So, and I don't know the relationship between the Comelec and the church insofar as financial matters are concerned. So I'm not ready to answer that question. I'm sorry.
Does Comelec have that authority or power to make sure that all the paraphernalia out there are not at the behest of a political candidate?
I'm sure it has, Your Honor.
So it also has the jurisdiction to regulate the tarpaulins and how it came to being by the diocese.
Again, Your Honor, if Your Honor, please, I am not familiar with, I'm sorry I could not answer that question. I'm not familiar with how the Comelec and the church has in relation so far as finances are concerned.
Justice Cardiel. Justice Abad.
The Constitution provides for freedom of religion. You agree with me?
It does, Your Honor.
And part of the freedom of religion is to, well, develop teachings in accordance with one's religious beliefs, correct?
Yes, Mr. Justice Abad, Your Honor.
Well, in this particular case, the teachings of this particular religion, the Catholic religion, goes against the RH bill, against the philosophies behind the RH bill. Is that correct?
Yes, Your Honor. Insofar as the encyclicals...
Is that part of religious freedom for those belonging to a particular religious belief to air their criticisms of stands that oppose their beliefs?
Well, insofar as the Bishop Bacolod is concerned, he believes so, Your Honor.
Would you consider it part of religious freedom for those who believe? Like, for example, I have a certain religion and this is my belief. And I make a statement on the conduct of a public officer that acts in accordance, in contravention of what I believe in. For example, if it has I believe in life rather than death, and in the matter of contraception, etc. Yes, it's an assumption. I have not yet made up my mind. Would you say that will be part of?
Yes, it could be. It should be part of religious speech, Your Honor.
Freedom of religion. No?
Yes, Your Honor.
To manifest and advocate one's belief.
Yes, Your Honor.
Now, can the state prevent people who wants to express their beliefs and tell them you cannot do that. It's election time. Therefore, you are not free to, since these public officers that you are, whose behavior you criticize are candidates in the election, then you cannot make a statement against their behavior.
If Your Honor, please, in order for the state to interfere with one's or curtail one's religious freedom, there must be a compelling state interest. And in this particular case, we don't believe that the state has enough interest, even insofar as fair and honest elections are concerned, to curtail religious expression, Your Honor.
Because it so happened he's a candidate, but he's also a public officer, one of those who took a position that contravenes my religious belief and have the freedom to make expression concerning that behavior. Is that not right?
Yes, Your Honor. But again, as I've mentioned, there must be some compelling state interest which curtails religious freedom, even in that sense, Your Honor.
Now, and this, you put posters in residence with the permission of the owner. Does it mean that the poster is to be inside the residence and that it will not be seen by the public? I think that's what.
There's no stricture. There's no stricture.
There's nothing like that, no.
There's nothing in the.
If permission precisely, yes. They need permission so they can make it public. People who pass the street are going to see it.
I agree, Your Honor.
So, is there anything wrong about the bishop who, in front of his church, places this for people passing by to be able to see?
I find nothing wrong with it,
in the
Your
same
Honor.
manner as a person who gives a consent to take a poster of a candidate and post it on his wall.
I think that is the lesson also in Adjong, Your Honor. That's not only part of religious freedom, it was also part of his free expression. He can post whatever he wants insofar as private property is concerned, wherever and whenever, and we don't see any limitation insofar as that's concerned.
Well, unless the limitation is you watch out for the Comelec official with the measuring stick, and anything that exceeds that 2 by feet will be violation of the law.
Yeah, that's
the risk you take.
That's the risk you take, Your Honor. But insofar as that is concerned, I don't think that it's practical for them to go around with the measuring stick. If Your Honor, please, if you go around the cities, even in Bacolod City, there are posters much larger than the poster put up by the church. In places even more visible than the church wall.
In the same way that other religion can also put up posters, because I don't think the Catholic Church is the exclusive right to make pronouncement like this.
No, Your Honor.
There are, I think, some evangelicals or other groups that believe in the RH bill, and do you think they should be allowed also to put up their own posters that promote?
If Your Honor, please,
their advocacies?
They should be allowed to put up whatever posters they want insofar as their advocacy is concerned. There are actually also certain religions and certain religious which support the arts.
Which do you think is the dominant message? The dominant message as a criticism for the behavior of these persons, and that therefore they're not worthy to be elected, or more for enhancing their candidacies or trying to defeat their candidacies in the election? Which do you think, a statement concerning a principle regarding the issue of life, or a statement concerning just saying that a person has all the qualifications to be elected?
Insofar as the church is concerned, Your Honor, in this particular case, they're only talking about information and instruction, because one of the most important parts of Catholic faith is that every person is allowed to an examination of his conscience. So here the church is instructing the faithful that they should examine their conscience and determine whether or not they should vote for a particular candidate. So again, there's nothing there in the poster which actually tells you that this person has no redeeming value, this person is totally bad, etc., Your Honor. This is just an expression of the church insofar as it's
behavior. A behavior that the church condemns in that particular case.
Yes, the church does condemn certain behavior, but insofar as this poster is concerned, I don't think there's anything there. The church does other media, Your Honor. They do seminars, and they
Okay, thank you very much.
Thank you, Your Honor.
Counsel, can you confirm the news report that actually the Diocese of Bacolod has already halved the disputed poster?
If Your Honor, please, Madam Chief Justice, the last time I looked at the tarpaulin, which was, I think, 2 days ago, what had happened is that they had placed the tarpaulin back together again. So it's now one whole instead of... They have it and then...
For a time, in other words, for a time, in order to comply with the Comelec regulation, they halved it. And then they placed it as if it was still existing as an integrated whole with a space in between.
I don't know the exact reason why they have it, Your Honor. I have it on.
And from the way I look at it, it was nice actually.
Which one, Your Honor?
The halved.
Well, actually, the other reason why it looks good halved because
because I could read everything there, even though there were two posters, effectively two posters, one on top of the other, produced from a single poster. I could read everything, and there was not a single message that was there in the two parts of the poster that was diluted in any way.
Then we should have it, Your Honor. However, Your Honor, please.
In fact, I assume, therefore, that the message that you could actually deliver was that it could be it could be sent in stages, in parts, and then the message apparently is not diluted.
If Your Honor, please, but it still does not comply with the 2x3 requirement, Your Honor, because 2x3 is quite small.
In other words, if you can have it again, in other words, if you had divided into 3, it would have perfectly complied with it, something of that sort. In other words, the point is, according to Comelec Commission Chairman Mr. Brillantes, he was saying that if you had wanted to put 1,000 or X number of posters side by side with your message, they would not really have objected. What they had objected to was the inability to put in the message which affects election within the size constraint. There is absolutely no objection to the content.
If Your Honor, please, then insofar as the 2x3 size is concerned, then it doesn't mean anything. If you put the 2x3 size together, then from all appearances, it will not be 2x3 anymore. So we don't know the reason for the 2x3 insofar as the...
Did you even try? Did the diocese even try to comply with the Comelec regulation?
Insofar as I could recall, Your Honor, it has not, Your Honor.
So the Comelec, according to its own public pronouncements, does not intend to interfere with what you wanted, the diocese wanted to put in the posters, as long as the posters are of a certain size, because inherently it has to somehow introduce regulation. That's the entire theory there.
Yes, we understand that. We understand that, Your Honor.
Okay, now you have already said that this is in accordance with the freedom of conscience of the Church to the Diocese of Bacolod principally. Now, I also read the Bible, Mr. Counsel, and in the Bible, Jesus is quoted as saying that you have to render unto Caesar what is Caesar's. What do you understand by that, Mr. Counsel?
Well, insofar as that is concerned, what Jesus is actually saying, what the state should be separate from the church.
He basically was saying, if there is a government regulation ordering the payment of taxes, even if God owns the whole world, then those who follow him should also pay their taxes, correct?
Yes, Your Honor.
In other words, he wasn't telling his followers to violate their conscience.
Yes,
he was just saying that if there's really nothing wrong with following a regulation, well, you go ahead and follow it, right?
If Your Honor,
so
please.
What was the very difficult, what was violative of the conscience of the Diocese of Bacolod to put side by side or one on top of the other posters that will amount to the same message? After all, when I looked at the publicized pictures of your cut-up posters, they really made sense, and the message was loud and clear.
If Your Honor, please, again, insofar as the Bishop of Bacolod is concerned, and because of the visibility of the present poster, he believes that this is the proper size for those posters are concerned.
Have you seen posters along highways and even along on televisions where letters are put one beside each other and they deliver a good message also.
I have seen that.
In other words, it is also a communication medium
Yes,
to chop up the size of the materials to be posted. And in fact, they even carry sometimes a louder punch than that.
I understand that, Your
Could the
Honor.
diocese not have tried its best?
If Your Honor, please, I am not at liberty to
Yeah,
tell the diocese.
the reason why you have to look at this is because in a world that requires regulation for order to be seen, it appears that even Jesus was encouraging his disciples, according to the Bible, to follow regulations also. In other words, was there a good faith attempt to follow Comelec regulations that governs the size of posters when the posters advance or detract from the chance of a candidate in an election?
We understand that, Your Honor.
Yes.
But again, that's the bishop's decision insofar as the size of
So
the
are you saying that the bishop's sole decision on even the size of the materials is an unbreachable right on the part of any religious person?
Insofar as the bishop is concerned, Your Honor, and insofar as the
Yes,
city of
but
Bacolod,
we are here this is a court of law.
well,
Mr.
insofar,
Counsel, this is a court of law and you have to prove your point by using legal principles.
insofar as
Was
the,
his
if-
conscience violated when he is just being asked by Comelec to put his message within a particular size?
I am not at liberty to say what the bishop's
But that is the
conscience-
point that is being made by the petition. Because the petition is basically saying even the sizes of your materials cannot be regulated. Let's transpose this illustration to another situation. Supposing that the Bishop of Bacolod wants to send in a religious material through the Philippine Postal Service. And the Philippine Postal Service says that it cannot accommodate sizes, materials of a particular size because of present regulations, whether it's caused by logistical regulations or it is caused by government regulations governing transportation of materials. Can the Diocese of Bacolod, can the bishop say, we cannot follow that because you are violating our right to have our materials in any size we want them?
If Your Honor, please, then that has no element of speech or expression anymore. Just sending it to the mail.
So
removes it out-
exactly.
removes
If you
it-
are saying, no, sending of materials through the mail is a protected right.
It is, Your
It's a
Honor.
protected right. Because if you want to communicate your views through the use of the mailing system, you have the right to do that. But the point is it a violation of that right if the only regulation that is really being enforced is the size?
Insofar as the sending of the religious material by mail, Your Honor, that does not, as far as we're concerned, that does not violate religious freedom and religious speech, Your Honor.
Now, was it too unreasonable to request or to require that all materials that tend to influence the election of a candidate or not be in a certain maximum size? Is it the height of unreasonableness, or does any person, in fact, have the duty to try in good faith to follow these state regulations that do not attempt to censor the content of that material?
I'm sure the bishop has thought long and hard about whether he should put up the poster or not. I think that's also the reason why at some point they did try to separate the poster, but eventually they came up with the decision that they were going to stand
So
by
are
the
you
size.
basically saying it is an individual decision? I mean, we are not here asking, I am not concerned with what is there inside the poster. That's not my concern at this point. My concern is, why could that message not have been contained within the size that is provided for by the Commission on Elections?
Again, Your Honor, the bishop feels that the 2x3 size is not.
But it's not a matter of feeling. It's a matter of, this is a court of law, and you have to argue under what legal principles the state cannot regulate the size of materials. Even the media, whose rights we are very protective of, they have regulations that they have to comply with every time. And we are very conscious of the need to regulate even those instances. No, it is just a question of whether the conscience is violated if one has to follow a size regulation. That's all.
Again, if Your Honor, please, insofar as the size is concerned, it's the bishop's contention that it does violate his freedom of expression.
We know, but what is your legal argument to persuade us that regulating the size of a material is violative of one's religious freedom?
If Your Honor, please, can I cede the floor to co-counsel?
Okay, will you give up your floor now to
Yes,
co-counsel? Justice Lonen will let him proceed on his ground, and the others are now free to proceed also on the issues that you tackled. Okay.
Your Honor, because the counsels for the petitioners have agreed on a division of the topic that we are to take up, and particularly questions about size would have been taken up by this representation. And so I'll be the one who should be answering about the size of any question about the size of the poster, Your Honor. Well, we understand your concern regarding the size of the poster, Your Honor, and we understand that based on the comment of the Office of the Solicitor General, they would like to make it appear that this is just a question about the size, Your Honor. But we do believe, Your Honor, we submit that this is not only a matter about the size of the tarpaulin, Your Honor. They would like to make it appear, Your Honor, that this is a content-neutral regulation, and that is what is being regulated
proceed
by.
with your argument. We read his comment.
Yes, Your Honor.
You don't have to repeat his comment, please.
Yes, Your Honor. So they're trying to say that what's being regulated is only about the size. But, Your Honor, regarding the size of the tarpaulin, Your Honor, we actually have no problem complying. The bishop actually has no problem complying with the said regulation, provided, Your Honor, it would apply to all tarpaulins. And so with that, Your Honor, it would be a content-neutral regulation. But in this case, Your Honor, it's not a content-neutral regulation.
What do you mean? You are amenable to coming up with a 2x3
provided, Your Honor,
tarpaulin, provided that?
Such regulation would apply to all tarpaulins.
All what?
All tarpaulins, Your Honor.
So not only election
Not
tarpaulins.
only election tarpaulins, Your Honor, because we have to consider, Your Honor, that there are two particular types of expression, Your Honor, commercial and non-commercial speech, Your Honor. This particular kind of expression, Your Honor, is a non-commercial speech, Your Honor. It's not only a political speech, it may also be considered as a religious speech, Your Honor. And either way, Your Honor, either you consider it a political speech or religious speech, they are to be, or they deserve a high protection in the hierarchy of constitutional values. Your Honor,
And why did the diocese not object when the Comelec was issuing such regulation about the size?
Precisely, we went directly to this Honorable Court, Your Honor, as the last bastion of freedom and democracy, because we do believe, Your Honor, that it's only this Honorable Court that can give the proper redress to the repression of this
But
basic
how
right
can
to
the
freedom.
Comelec regulate or issue any regulation over any material that has nothing to do with elections?
Well, that is precisely the point, Your Honor. It's a question of power. It's a question of whether the Comelec was given by the Constitution or by law such a power. And so we submit, Your Honor, that...
So you are basically saying the Comelec has no right to regulate the size of the materials?
Well, when we are talking about...
on election time, it has the right and it has the duty to regulate all the sizes of all kinds of materials.
That we understand your point, Your Honor, but that is not exactly correct, Your Honor, if we will base it on the Constitution. As this court
No. Let's go back. I
No.
don't want us to lose track. The Diocese of Bacolod does not have any objection to the regulation of the size of the tarpaulin as long as it also applies to commercial and other non-election materials.
Not only that, Your Honor.
Okay, so I'm now asking you.
Yes,
But this is a petition you brought against the Comelec.
Yes, Your Honor.
But does the Comelec have the power to regulate the size of materials that have nothing to do with elections? And you are saying that's precisely the point. We want everything to be regulated. So, but again, this is a court of jurisdiction. The jurisdiction of this court is limited to its acquisition of jurisdiction over the respondent that you had named. And you had named only the Comelec. How can we make the Comelec account for the size of the tarpaulins of commercial billboards, for example?
And that is why precisely, Your Honor. First, Your Honor, this, pursuant to the principle of nemo est supra leges, this should be a government of laws and not of men. And therefore, we must look into the law. We must look into the Constitution. And so, precisely, has the Constitution given the Comelec such power to regulate such a kind of tarpaulin when posted on private property by a person who is not a candidate nor a member of any political party. We do believe, Your Honor, that Comelec was not given such authority. The authority given to the Comelec, Your Honor, was only to regulate franchise holders, holders of grants, holders of permits, Your Honor.
One issue at a time. Size. Okay?
Your Honor.
Size. Are you now basically asking us to say that the Comelec should also extend the same regulation to non-election materials?
No,
Only
Your Honor.
that.
That is not what we are saying,
Okay.
Your Honor.
Now, so
What-
if your remedy is for us to allow the publication of materials that are beyond the size that has been given by the Comelec, who should we call here to appear before us now?
No,
Because
Your
we
Honor.
are concerned by your alarm that commercial materials can be large, but commercial materials have to be smaller. So who do we call here now, Mr. Counsel?
No, if Your Honor, please.
Should we
that's
call
not-
Congress?
Yes, Your Honor. That is
We
not
should
actually.
call Congress. So
No.
why didn't you implicate the entire Senate and the House?
No, Your Honor. If I may be allowed to explain, that is not the point of the petition.
So what is your point here?
Our point,
Remember,
Your Honor,
Remember, we are talking about the
Yes,
powers
Your
of the Comelec. You confine it to that. Otherwise, we will get lost. Okay, continue.
Yes, Your Honor. Now, what we are saying is that Comelec does not have the power. It's not that we should also regulate other, for example, non-commercial billboards or tarpaulins. What we are saying is that since no such regulations is being imposed on other types of tarpaulins, like commercial tarpaulins, then Comelec and of course, ultimately, the government should not regulate this form of expression by a private
Is
individual.
classification itself by the Comelec of regulation over election versus non-election materials, is it unconstitutional per se? Does the Constitution require equality in all situations?
Not necessarily,
That's
Your
a
Honor,
basic-
but
okay.
the classification must, of course, be reasonable, Your Honor.
But this is the Comelec that we are talking about. Of course, it can only regulate election-related materials. What else can it regulate?
Well, precisely, Your Honor, it cannot regulate this kind of.
So you are
material.
basically saying because there are no size restrictions on non-election materials, the Comelec therefore does not have the power to regulate election-related materials.
No, Your Honor, that's not the point.
I thought that was the
Comelec, Your
point.
Honor, has the power to regulate election materials provided they have been
That?
posted by candidates and political parties. Comelec is also
Ah,
given
okay.
the much leeway in posting in public places, but we are talking of a private
Okay,
place.
now
Your
we're
Honor.
getting somewhere. You're basically saying now, as long as it is posted by candidates and political parties, they can regulate. But private persons, they cannot regulate. But that's already settled the jurisprudence. The Comelec basically has the power to regulate even the behavior of non-political parties and non-candidates.
Yeah, Your Honor, but with respect to posting of posters or tarpaulins, Your Honor, I think the jurisprudence on the matter by this Honorable Court is the Diong versus Comelec, Your Honor. And
What-
the posting, for example, in that particular case, what was involved was the posting of decals and stickers on mobile places. And this Honorable Court held that
You mean
that
the
is
moment
part
that
of...
it is a private material produced by a private party, it cannot be classified already as election material?
Well, Your Honor, we must distinguish, Your Honor. When say election material, insofar as it was posted by a candidate, then it may be controlled, it may be regulated by the Comelec. But when it is posted by a candidate who is merely exercising freedom of expression and expressing his preference of whom he would like to vote or whom he would like to be voted upon, and is right to communicate that message to other people, trying to convince others to agree with his own opinion regarding his preference of candidates, that is part of freedom of expression, Your Honor. And that is what we are trying to...
In other words, as long as Comelec itself is not able to audit and trace a particular poster to a particular candidate, all posters of any kind cannot be regulated.
Well, Your Honor, as we have mentioned, Your Honor, it's a question of power. So what power in particular was given to Comelec? So the only power given to Comelec was to regulate
Election materials.
election materials, Your Honor, posted by candidates, Your Honor, and political parties, and that is clear from the Constitution and the law. Because we have to base it, Your Honor, on Section 9 of the Fair Election Act, which is implemented in Section 17 of Comelec Resolution number 9615. And all it says, Your Honor, is parties and candidates may post election propaganda materials in private places provided they have the consent of the owner thereof. Now, so we are talking about regulating, on the part of Comelec, regulating campaign materials or election propaganda materials that are provided by candidates or political parties in private places.
So now that is now your issue. You're now confining your issue to whether the Diocese of Bacolod falls within the terms of the law such that its materials can be regulated. First, can be classified as election material, and second, can be regulated. Is that now your issue?
Yes, sure.
Okay. It's not really freedom of religion, but it's basically that it does not fall within the category of the law's language.
Well, in addition to the principle of separation of church and state.
Okay, I will stop there and I'll ask allow the others to ask.
Okay, right.
Scarpio.
Yeah, you're saying that there is no provision in the Constitution that would regulate this kind of tarpaulin put up by your client. Is that what you're saying?
These tarpaulins, Your Honor, are protected by the Bill of Rights, and therefore they are not subject to regulation by the Comelec insofar as they are the one posting the same are private persons, Your Honor, especially in the confines of their own private property.
Doesn't the Constitution authorize Congress to pass a law limiting election expenses, including the placement of posters in certain places? And that Congress did pass a law, correct?
Yes, Your Honor.
So under Section 82 of the Omnibus Election Code, there is a provision there saying what are unlawful election materials, correct?
Yes, Your Honor.
And if it is beyond 2 by 3 feet, that poster becomes illegal, correct? Under the law.
Not necessarily, Your Honor.
Why?
They are election campaign propaganda material in Section 82 of the Omnibus Election Code, and that must be, we would like to submit, Your Honor, that must be read in relation to the provisions on postings.
Okay, so you agree that Section 82 is a constitutional limitation on freedom of expression or of religion. As far as election materials are concerned, there is a valid regulation under the law, Section 82, correct? 2 by 3. Now, as to how that is applied, that's another question. But there is a law, correct?
Correct, Your Honor.
It should not exceed 2 by 3. Okay. You are saying that this provision does not apply to non-candidates. It applies only to candidates and political parties.
Precisely, Your Honor.
So if the bishop, who is a private citizen, is not a candidate, he doesn't belong to any party, puts up this tarpaulin saying, vote for this, don't vote for that, that is not covered by Section 82. That is your proposition, correct?
Yes, Your Honor.
Because
that's an expression
the law
of preference.
On Section 82 applies only to candidates and political parties. So your position will rise or fall on this issue, whether Section 82 applies to private citizens also. So you are saying that any citizen now can put up tarpaulins all over the country, regardless of size, and he cannot be regulated. He cannot be stopped because Section 82 does not apply to him. It applies only to candidates and political parties. That is your proposition.
Well,
correct?
that is the fear being expressed by the government with respect to this matter, Your Honor. But that
is your proposition now. That's what you're saying, correct?
Well, Your Honor, if that would enhance the exercise of freedom
my
of
question
expression.
is, that is your proposition, correct?
Yes, Your Honor. That is our proposition.
Okay. But you agree that there is a valid constitutional law regulating the size of tarpaulins. Only, it applies only to candidates and political parties. It doesn't apply to other citizens, correct?
Correct, Your Honor.
Okay. Where does it say that it does not apply? Look at Section 82. Is there a limitation here that it applies only to candidates and political parties?
Section 82, Your Honor, is only a description of what are lawful propaganda
So
materials.
it says here, lawful election propaganda shall include. Therefore, if it exceeds 2 by 3, it becomes unlawful, correct?
Correct, Your Honor.
Okay. So Section 82 does not say this applies only to Mr. X, it does not apply to Mr. Y. It says this is a crime. If you have a tarpaulin exceeding 2 by 3, it's a crime, correct?
Only insofar as it does not infringe on freedom of expression, Your Honor.
So you are adding a qualification of, earlier you said this is a valid and constitutional regulation. Now you're saying it will infringe on freedom of expression.
No, that is part of the assumption, Your Honor, as I was trying
Okay,
to
we
follow your
already
argument.
agreed that the Constitution has authorized. The Constitution itself, it says there is a Bill of Rights and there is also authority of Comelec to regulate what is in the Bill of Rights. Expression is regulated during election period. That's in the Constitution.
I haven't seen that in the Constitution. I'm
Okay.
sorry, Your Honor. The power given to Comelec,
Okay,
Your Honor, was...
Section 2.7 of Article 9. Can you read it?
Well, that is in may I be allowed to get a copy, Your Honor? Section 2.7.
Article 9. That is the basis of all of this regulation, that provision.
Sorry, Your Honor, I have no copy at hand.
Okay, I will read it to you. The Commission on Elections shall exercise the following powers and functions. Recommend to Congress effective measures to minimize election spending, including limitation of places where propaganda materials shall be posted. That is the basis for Section 82. That's why there is a regulation on election materials. And it's in the Constitution. So you cannot say it's unconstitutional.
It doesn't say anything about freedom of expression, Your Honor, or controlling or regulating freedom of expression.
You mean to say that the framers were wrong? They should have placed here, despite the Bill of Rights recommend it can do this. You have to read it side by side.
Yeah, but
there is the Bill of Rights, and there's another provision regulating it. And of course, that regulation, which is special, it applies only to the election period, will prevail, provided it is a reasonable regulation. Are you saying that this is unconstitutional, Section 2.7?
No, of course, Your Honor, that is a provision of the Constitution.
You earlier agreed that Section 82 is valid and constitutional provision, correct?
Insofar, Your Honor, that it would be made to apply to everybody, Your Honor, and it would not infringe on basic freedoms like freedom of expression, then it would be valid. That is our
the law does not say that. You tell me, you said this is valid and constitutional.
I said, Your Honor, insofar as it would not infringe
So every law now will be insofar. It's either unconstitutional or not. We don't distinguish.
Yeah, Your Honor, but a law would become unconstitutional if it infringes on basic constitutional freedoms.
But
and
we
so
already agreed that this is valid and constitutional because it emanates from the Constitution. Unless you're saying it, unless you're attacking now Section 82, the constitutionality. But you are not. You're not attacking the valid constitutionality of Section 82. So we presume this to be valid and constitutional in deciding this case.
Well, we can, for purposes of deciding this case, Your Honor, we can make that assumption, Your Honor, because actually, Your Honor,
so this is now valid and constitutional. So any size of tarpaulin that exceeds 2 by 3 will be unlawful. Correct? Because we have to assume that.
Not necessarily, Your Honor. Only insofar as they are posted by candidates and members of political parties, because that has always been our contention.
As I said, you are now saying that you must be a candidate or a political party
Your Honor,
to be bound by this. Okay.
Yes, Your Honor.
But I don't see that in Section 82. But you are saying we should read Section 82 together with the fair election law.
Yes, Your Honor.
Okay.
Particularly Section 9,
So
Your Honor.
we're getting somewhere. Okay. Now, look at Section 82. It says the tarpaulin should not exceed 2 by 3 feet.
Yes, Your Honor.
Okay. Does it say per candidate?
It doesn't.
Supposing you have a tarpaulin and you put one name only because you put it in a tree that is several meters from the road. So you put only one name. So it can be seen, correct?
Of course, Your Honor.
Okay. But if you put 8 names, it can hardly be seen, correct?
Correct, Your Honor.
If you put 12 names, nobody can make out of those names anymore, correct?
More likely, Your Honor.
So this 2 by 3 should refer only to per candidate, correct?
Perhaps, Your Honor, that would be
2 by
a reasonable
3.
interpretation.
The law does not say this is limited. All candidates must be put here by the political party. No.
Of course, sir.
The law is silent. So to read this reasonably, it is per candidate. So per candidate, especially if you put it in a place to be seen by motorists, it has to be bigger. So maybe 2 by 3 is just enough for one name. So if you have 10 names, then you multiply it 10 times, correct?
Well, actually, Your Honor, the law does not actually distinguish. So
Yes, the law does not say 2 by 3, whether it's one name or 10 candidates. It doesn't say that. It just says tarpaulin cannot exceed 2 by 3. So technically, as the bishop was saying, you can put those 12 names, or how many names? 8 names in the tarpaulin? Team Patay?
Yes, sir, I haven't counted actually. Your
Okay,
Honor. Yeah.
so if there
several
are
names.
8 names, he can put 8 2 by 3s with different names, correct? There's no prohibition. And that's what Comelec is saying. You can put 2 by 3s with different names, and the Comelec will not argue with you, correct?
Correct, Your Honor, but if that would be the case, Your Honor, then there is really nothing about the regulation of 2 by 3. Then it's actually nothing. So it's an arbitrary determination of the size.
No. What I'm saying is the 2 by 3 is really for just one candidate's name, correct?
Perhaps, Your Honor, but since the law does not distinguish, so you can lump all the names of candidates, or you can just use it for only one candidate.
You put 10 names in a 2 by 3 and you put it in a tall building, nobody can read it.
Yes, Your Honor.
So what the Comelec is saying, 2 by 3, you can put 10 names there, but 10 tarpaulins of 2 by 3, that's okay with them. So the reasonable interpretation of this provision is that the 2 by 3 refers to one name. So there is no prohibition. My point is, the law does not seem to cover a situation where you have 20 names in one tarpaulin.
It's actually irrelevant, Your Honor, the number of names in the tarpaulin. As we have
Yes,
mentioned, the law
because
does
if
not
it's a
distinguish.
political party, you may
Yes,
have,
sir.
from president down, you may have 50 names already, including party lists. So you cannot definitely put that in one 2 by 3. So the 2 by 3, it seems, applies only to one candidate. So what if you want to put up a tarpaulin with 12 candidates' name? Is that regulated? Is there a regulation in the law?
Well, I do not know with Comelec, Your Honor, but our contention is that if if Comelec would allow the lumping, or, if you will make a collage of 12 tarpaulins, so there would be no reason why regulate one tarpaulin to only 2 by 3 if you can combine everything and then make a bigger size tarpaulin, like in this case, let's say 6 by 10 or 10 by 16 tarpaulin.
So you are arguing from that point of view that in other words, if you follow that line of reasoning, then there's no need to regulate anything anymore.
Technically, Your Honor, because that is the point. Because in the words of the no less than the chairman, Your Honor, he said on television that the bishop can actually post and even cover the entire cathedral with tarpaulins as long as its tarpaulin is only 2 by 3 in size.
So from that, you are making the conclusion that there is really no reason for that kind of regulation, because you can always come up with 2 by 3 tarpaulins with different names.
Well, Your Honor, our contention...
But if you put up 12 names in one tarpaulin, it will be ineffective.
Of course, Your Honor.
So there is a limitation to that.
And that is why precisely, Your Honor, sometimes the size of the font used, it would necessarily dictate the supposed size of the tarpaulin.
Okay,
for example,
so
if you would lump 12...
there is this law, and as you said, it's presumed to be valid. So we have to read it and give it a reasonable interpretation. So a reasonable, from my point of view, 2 by 3 refers to one name. If you put it in a building and designed to be seen by motorists. So if you put 12 tarpaulins with one name each, there's no problem. Comelec will not run after you. But what if you put, as you have done here, 6 by 10 tarpaulin with 10 names? Is that regulated? Is there a provision of law? So that's what I'm asking you. Does the law regulate that, or is there a hiatus in the law? Is there a gap in the law?
Well, technically, Your Honor, as we have argued in our main presentation, Your Honor, it's not supposed to be covered by the law, Your Honor, because in the first place, it's the law, particularly the Fair Election Act, should only cover candidates and
So you
parties.
will fall back. That is your main defense. That
Yes, Your Honor.
this law is Section 82 is valid, but it does not apply to your client because your client is not a candidate or political party. Period. That's your defense.
So we are saying, Your Honor, that as applied to the petitioner, Your Honor, it would become invalid, Your Honor.
Yeah, as applied, because your petitioner is not a candidate.
Yes, sir.
It will boil down to that. It has nothing to do about religion. It has nothing to do about freedom of expression. It's just that your client does not fall under the regulation of Section 82 in relation to the Fair Election Law. That's what they're saying.
Your Honor, the size of the tarpaulin, if it would be regulated, and then the Bishop Bacolod or the diocese will be forced to resize it to only 2 by 3. Our contention, Your Honor, is that it will necessarily destroy the efficacy of the expression, Your Honor. So, Your Honor, the prominence
you
and the
reduce
size
it to
of the
2
message.
by 3 with all the names.
With all the names, Your Honor.
Yes, nobody will dispute that. If you put there 12 names in a 2 by 3, nobody will see that.
And on the part of the Bishop Bacolod, Your Honor, he doesn't want a lot of tarpaulins. He just wants one tarpaulin, Your Honor, containing and encapsulating the entire message. And this cannot be done in only a tarpaulin of only 2 by 3 size, which is only 6 square feet. And in fact, Your Honor, this particular that will necessarily destroy, as we have mentioned, Your Honor, it will necessarily destroy the efficacy or the effectiveness of the expression. So that would in fact be a violation of freedom of expression, Your Honor.
Okay, thank you, Counsel.
Thank you very much, Your Honor.
Okay. Justice Velasco.
Counsel, can you tell us what was the reason behind the posting of the tarpaulin on the wall of the cathedral? What is the reason why it was posted there?
Well, Your Honor, the posting of the tarpaulin was part of the campaign of the diocese against the RH law. You know, the RH law, Your Honor, it talks about persons who are pro-life and those who are in support of what is known and used in one papal encyclical as those who are in favor or working for the culture of death. And that is why, Your Honor, it was part of a catechetical instruction or message on the part of the Bishop Bacolod. Mm-hmm. On the part of the Bishop Bacolod, Your Honor, it was not a campaign material because the Bishop Bacolod, Your Honor, as posted in the tarpaulin, Your Honor, doesn't say vote. It only says conscience vote. And in the words of the Bishop, Your Honor, when I conferred with him, he told me his purpose was only to awaken the conscience of the people that this is the evil of the RH law, and these are the people who supported the RH law, and therefore, you have to examine your conscience. Are you going to vote for them or not? The bishop is not telling them to vote or not to vote for this particular group of people. The bishop is only telling them, is only trying to awaken their conscience so that they can vote in accordance with the dictates of their own conscience, Your Honor.
So, would you admit that this is a part of the information campaign against the law that was passed by Congress?
Yes, Your Honor. It's inextricably linked and connected, Your Honor, to the campaign and advocacy of the diocese concerning against the RH law.
And there was no intention on the part of the petitioner diocese to support or oppose the election of any particular candidate listed in the tarpaulin?
No, Your Honor, that is not the intention. The intention of the diocese or of the bishop, Your Honor, is not to support the candidacy or the defeat of any particular candidate or group or of candidates like party list groups. It's only, as I've mentioned, Your Honor, just to inform the people that this is the RH law, these are the people who supported it, these are the people who opposed it, and you have to examine your conscience. And you have to vote in accordance with the dictates of your conscience. So, as we have mentioned, Your Honor, so that takes it out of the concept of an election campaign propaganda material. Because to make it an election campaign propaganda material, its primary purpose and intention should be to promote either the candidacy or the defeat of any particular group of candidates or political parties. But that is far from the intention, the real intention of the Diocese of Bacolod, Your Honor, in the posting of this particular tarpaulin.
Is there any definition of the phrase election propaganda given by Comelec, whether in a resolution or in a or in the law itself, the Fair Election Act?
We have searched, Your Honor, the Omnibus Election Code, the Fair Election Act, and several Comelec resolutions, but we have not found any particular definition for an election campaign propaganda, nor for a political advertisement. But we are being guided, Your Honor, by the definition of an election campaign or partisan political activity, which are found in Section 79 of the Omnibus Election Code, Your Honor. So we are using this as basis of in determining whether a particular propaganda material should be considered as an election propaganda material or not.
Actually, in Resolution 9615, political advertisement or election propaganda is defined, actually, Counsel. And it's so stated here that it refers to any matter broadcasted, published, printed, displayed, or exhibited in any medium which contain the name, image, logo, brand, insignia, color motif, initials, and other symbol or graphic representation that is capable of being associated with a candidate or party and is intended to draw the attention of the public or a segment thereof to promote or oppose, directly or indirectly, the election of said candidate or candidates to a public office.
Yes, Your Honor, that is effect, you have mentioned Section 3, Your Honor.
Section 4.
Section 3 of Republic Act 9006,
9615. And it appears that...
Section 6, lawful election propaganda.
No, it's Section 4 on page 3.
Are you referring to the Comelec Resolution 9615, Your Honor?
No, sorry. It's Section 1 under definitions. I'm sorry.
Which may I ask?
Under Section 1. Sorry.
You are referring to Comelec Resolution 9615, Your Honor?
Right. Okay. And it appears that to be considered as an election propaganda, there are at least around 3 requisites, and that is that the propaganda is capable of being associated with a candidate or party. And do you admit that the tarpaulin where the message, conscience, vote, etc. is contained is capable of being associated with any of the candidates listed there?
Well, it may, Your Honor, but it's not actually associated with any particular candidate. Because the message, Your Honor, and the tarpaulin itself is a property of the diocese, Your Honor. The message and the tarpaulin did not come from any particular candidate or member of any or political party.
Did the tarpaulin draw the attention of the public or a segment thereof?
Well, I suppose, Your Honor, even that of the Comelec, Your Honor. And that is why we are here before this court.
Did the tarpaulin promote or oppose directly or indirectly the election of any candidate to a public office?
That is where we will differ, Your Honor. Because that is not the purpose and intention of the diocese in posting the said tarpaulin, Your Honor.
Okay, so your position is, since this is not an election propaganda, then the Comelec rules on the size of the propaganda or any print or matter which is used for publication or printing does not apply.
Precisely, Your Honor. That is the point of the petitioners.
So the petitioner diocese is not restricted by the Comelec regulation that a poster has to have a size of 2 by 3 feet, correct?
Correct, Your Honor.
That's all, Madam.
Justice Perez.
Mr. Counsel, are you changing your position? Because you're now saying that that tarpaulin we're talking about is not an election propaganda material. A while ago, you said, and your proposition is that whether or not it's election propaganda, it is outside of the powers of the Comelec to regulate, because you said that the Fair Election Act is applicable only to a political party and to a political candidate.
Precisely, Your Honor. Our point, Your Honor, based on our main presentation, is that we are saying that this is not an election campaign propaganda material. But nevertheless, we said, Your Honor, assuming arguendo, that it will be considered an election propaganda material, it will still not be covered by Comelec resolutions.
Okay, we proceed from that. You assume that it is an election propaganda material.
Assuming but without conceding, Your Honor, only for purposes of arguments, Your Honor.
And then you say that the Fair Election Act applies only to political parties and to a political candidate.
Insofar
And
as
that-
posting...
And that the 2x3 measurement applies only to a political party and to a political candidate. In other words, a political candidate cannot exceed the 2x3 if it is even if it is placed in a private property, but the bishop can go ahead in the national highway. Well, of course, in the national highway, these are private property. So long as these owners of this private property allow it, they can post all these materials larger than the 2x3 measurement.
Well, Your Honors, that is part of the risk that this democracy has to take if we are to be true to our freedoms, Your Honor.
In other words, the candidate himself or the party itself is limited by the law, but a private individual can do what the political party and a candidate himself cannot do or itself cannot do.
Your Honor,
That's
there
actual
is a compelling state interest in the regulation of candidates and political parties because they have subjected themselves to our election laws. The same cannot apply to a private individual who has not filed a certificate of candidacy, Your Honor.
There is such a thing as regulated expenses. A private individual posts all this and says, this is my expense. So the party is outside of the regulatory authority of the Comelec.
As long as he is in the exercise of his freedom of expression, Your Honor, I think that is part of our democracy, Your Honor.
Okay, so that is how you construe the law. We will now give a new, what do you call this, interpretation to get out of that prohibition against too much election expenses.
There is actually nothing...
Because so long as the election propaganda is posted by a private individual on a private property whose owner allows it to be posted there, there can be no limitation. It is beyond the authority of the Comelec. Is that what you're saying?
Yeah, precisely, Your Honor. That is our point, Your Honor. And in fact, Your Honor, Justice Black, in his dissenting opinion, in Dennis versus U.S., Your Honor, he said that is actually the risk that democracy has to take if we are to protect these basic freedoms.
Are you not construing our elections law in an absurdity?
Well, in the first place, Your Honor, we are not the ones who caused the absurdity.
Okay, so
it is Comelec,
you are
Your Honor,
saying
who
that
caused
the law
the
is absurd.
The law may be absurd, Your Honor, insofar as
no more further
it's actually
questions,
absurd, Your Honor.
Justice Del Castillo, and then Justice De...
This is a follow-up question to the questions of Justice Perez.
Yes, Your Honor.
You're saying that the size limitation of the tarpaulins may apply only to candidates and political parties and not to individuals who are not candidates. That's what you're saying, no? The
Yes,
size
Your Honor.
limitation.
They should not be covered by this limitation.
Don't you
Your
think
Honor.
that would be a violation of the Equal Protection Clause of the Constitution?
Not necessarily, Your Honor, because there's a valid classification here. We are talking of candidates who have filed certificates of candidacy, and therefore they have assumed to comply with our election laws. And on the other hand, Your Honor, we are talking of a private individual who is not a candidate, nor a member of any political party, not vying for any public office, nor supporting any particular candidate. And I think that is a valid classification, Your Honor. Leeway is given to the Comelec to regulate the acts of candidates, Your Honor, and political parties during elections, but such cannot extend to the acts of private individuals who are in the exercise of their freedom of expression.
But don't you think that both tarpaulins are geared towards the election or the defeat of a candidate?
Well, Your Honor,
Yes,
Your Honor, I understand your point. They may actually have the same effect. But we must make a vital distinction here, Your Honor. It may be a hairline distinction, Your Honor. On the one hand, Your Honor, we are talking about an election campaign propaganda material posted by a candidate and therefore promoting his own candidacy or, promoting the defeat of the opposing candidate. On the other hand, Your Honor, we are talking of a private individual who posts a tarpaulin for purposes only of expressing his preference. Like, for example, I am for this particular kind of candidate, Your Honor. Now, if this honorable court would say that is not part of the freedom of an individual, Your Honor, then we will submit to this honorable court. But we do believe, Your Honor, that That is not what the Constitution says, Your Honor. The Constitution gives the individual the freedom to express his preference with respect to candidates, Your Honor, and that is part of his freedom.
There seems to be a clash now between two constitutional rights: the right to expression and the equal protection clause. Will you not concede at least that the freedom of expression could be incidentally burdened, as it has been ruled before?
Well, Your Honor, first
Because
let us try
time,
to
so
first, Your Honor, let us try to examine if there really is, if these two values that are both protected by the Bill of Rights cannot stand together. Now, we have equal protection on the one hand. Now, equal protection would be valid, or a valid classification would be valid if there is a substantial distinction between the two classes of individuals. Now, we say, Your Honor, that there is actually a substantial distinction between candidates and non-candidates, therefore paving the way for a different set of regulations that may be applied to candidates and a different set of regulations that may be applied to non-candidates. And therefore, Your Honors, there should actually be no conflict, or these two particular provisions are not actually antagonistic. But even assuming, Your Honors, that the Equal Protection Clause would be in an antagonistic position, or would be in opposite position, or would be in conflict with the right to freedom of expression, I think, Your Honor, the solution is very easy. In the hierarchy of constitutional values, Your Honor, freedom of expression occupies a high position. And therefore, the solution is actually very simple. This court should only favor freedom of expression in that particular, if that particular case would happen, Your Honor, that they cannot be reconciled.
Thank you, Counsel.
Justice De Castro.
Okay, there's no problem about the power of Comelec to regulate the conduct of election. There's no dispute about that.
Yes, Your Honor.
But let's look at this part by part. Let's deal with public places, the posting of campaign materials in public places.
Yeah.
Now, you raised earlier the issue of commercial posters not being regulated as to their sizes, as compared
Yes,
to election materials, which Comelec required to be limited to 2x3. Now, can you perceive any substantial government interest which made Comelec to limit the poster to 2x3? We're referring to public places. When there's no such motivation on the part of any other government agency to limit the size of commercial billboards, which may be as big as 15, 20 feet.
That is precisely our point, Your Honor. If this is a mere regulation of the incidence of speech, Your Honor, then only a substantial or an important interest would suffice to regulate freedom of expression. But since this is not actually a content-neutral regulation, Your Honor, so it would require a compelling and a substantial state interest before this particular kind of expression can be regulated. We believe, Your Honor, as held by this no less than by this Honorable Court, in the case of Adiong versus Comelec, Your Honor, that even the interest, even the mandate given to the Comelec to ensure free, honest, orderly, fair, and credible elections is not compelling nor substantial enough to curtail such a vital and preferred right of freedom of expression. And so removing that mandate to Comelec to ensure free, honest, orderly, and peaceful elections on the equation, we will be left with nothing, Your Honor. Comelec will be left with nothing. The government will be left with nothing insofar as establishing any such compelling or substantial state interest, Your Honor, which would be enough to justify a curtailment or a suppression of speech, Your Honor. Other than that particular mandate, Your Honor, we cannot find any other compelling state interest which would justify a suppression of speech, Your Honor. Speech is very important, Your Honor, unless the government can really establish, and the burden should be on the burden, Your Honor, should be on the respondents. Whenever there is a serious allegation of a violation of a basic freedom like freedom of expression, the burden, Your Honor, shifts on the part of the respondent. They have a heavy burden, Your Honor, to establish the constitutionality of such a repression of speech, Your Honor. And failing in which, Your Honor, if they cannot discharge that burden to establish or to show compelling state interest, then the repression of speech, Your Honor, that regulation of speech, Your Honor, must, it must be struck down, Your Honor, as unconstitutional.
What is the compelling state interest to peg it to 2 by 3, not 3 by 3 or 3 by 4 or
Precisely
3 by
the
5?
point, Your Honor.
Why is 2 by 3 used as a standard?
Precisely the point, Your Honor. We do not also understand why 2 by 3, Your Honors. And that's precisely the point of the petitioners, Your Honor. There is no compelling state interest in limiting this particular kind of expression made by a private individual in the premises of his private property to only 2 by 3.
Talking about public places, not private property yet. We'll go to that.
Well, in public places, Your Honor, we have no problem with that, Your Honor. In public places, Your Honor, government is given, acting through the Comelec, is given much leeway, Your Honor, because we are talking about public property, wherein, the exercise of private rights and private freedoms is, may in some way be regulated to some extent as compared to when he exercises or a person exercises the same within the confines of a private property. And insofar as posting of tarpaulins, Your Honor, in public places are concerned, we have no problem with that, Your Honor. Comelec has sufficient power under the Constitution and under the law to regulate such in public places, Your Honor.
Now let's go now to privately owned property. Do you see any compelling reason why an election campaign material should be limited to 2 by 3 in a private property?
I cannot find any, Your Honor. I spent a lot of nights and days, Your Honor, searching on that compelling state interest, but sadly, Your Honor, I cannot find any.
You will concede that there may be a compelling state interest to limit the campaign poster to 2 by 3 when it is a public place. You will not seriously question that.
We will not question that, Your Honor.
No, and you will have a problem if it is a private property where the poster is limited to 2 by 3.
Actually, Your Honor, we are not saying, Your Honor, the petitioner is not saying that it is absolute on the part of the government acting through the Comelec, that it is beyond its powers under the Constitution or by law to regulate this particular kind of expression when they are in private property, Your Honor. What we are saying is that it's not absolute, Your Honor, but the right may not be absolute, but any such regulation, Your Honor, must be reasonable, and it must not foreclose the efficacy and the effectiveness of the message, Your Honor. So, for example, Your Honor, if it is only for purposes of, for example, concerns, compelling interest because of the possible safety concerns, like, for example, a huge tarpaulin may implicate some concerns about danger or safety to the public in case it falls down. So that is a compelling state interest, Your Honor, the possible risk of danger. In some cases, Your Honors, for aesthetic reasons, some states were also allowed to limit or to put some reasonable restrictions on the size and sometimes even on the physical characteristics of tarpaulins. As held, Your Honor, by the U.S. Supreme Court in the case of City of Ladue versus Gilio, the state may regulate the physical characteristics of the tarpaulin as long as they are reasonable and as long as they do not infringe on basic constitutional freedoms. And as long as the determination of the size restriction is not arbitrarily determined on the part of the state, Your Honor.
So you would like to invoke the constitutional guarantee of right to property. When it comes to private property, you believe that there is much more leeway in the posting of election campaign materials
Yes,
as compared
Your Honor.
to a public place.
Particularly because, Your Honor, going back to Section 1 of the Bill of Rights, no person shall be deprived of property without due process of law. And in this case, Your Honor, if we will examine the order of the Comelec, it calls for the immediate removal of the property because in the wordings of the order of the Comelec, Your Honor, it was found to be in violation. There was not even due process. The private property owner, Your Honor, the Diocese of Bacolod and the Bishop of Bacolod was not even given the chance was not even given the notice and the chance or opportunity to answer why this particular type of tarpaulin, in the interest of due process, Your Honor, and in the interest of fair play, Your Honor, should not be removed on the ground that it's not regulated by Comelec resolutions. But in this case, Your Honor, there was already an immediate condemnation. It was already found to be in violation of Comelec rules and regulations, Your Honor, and there was already a direct order to have it physically removed. And under pain of the possibility or the threat of the filing of election offense against the bishop.
Let's go now to election expense in relation to the posting of an election campaign material in a private property. Assuming that the poster is only 3x3 or 4x5, will that involve much cost to the one posting it as compared to the one who posts just 2x3, a poster of 2x3 in size?
Well, of course, Your Honor, the expense, the cost of the printing and the preparation.
Before I asked that question because there is this issue about regulating election expenses. So I'm going back to the size of 2x3. If the size is 4x4 or 3x3, will that involve too much election expense so that that will now come within a compelling state interest to regulate?
Well, Your Honor, of course, necessarily, the cost of printing of the tarpaulin is based on square foot. And that is why, for example, a tarpaulin of only 2x3, that's only 6 square foot. So if the price will be based on square foot, of course, a tarpaulin with a bigger size, for example, 4x4 or 5x6, will cost higher as compared to a tarpaulin of only 2x3. And necessarily, therefore, it will entail much expense as compared to a tarpaulin of only 2x3. But with respect to your concern, Your Honor, regarding election spending or election expenditure and the authority of the Comelec to audit the same or to put limitations upon election expenditures, Your Honor, it is also our contention, Your Honor, although this is not anymore part of the issues before this tribunal today, Your Honor, our answer to that concern, Your Honor, is that those particular rules regulating election expenditures, Your Honor, are only applicable, again, only to candidates and political parties.
The point that I'm trying to drive at is that the law is not so clear when it comes to private property. The language of the law is so broad, and there is a provision saying that private property, as long as there is the consent of the owner, will not be covered by the regulation on lawful campaign material. So if there is a substantial distinction under the Constitution between a public place and a private property, because you will now be getting into the issue of the constitutional guarantee that no one shall be deprived of his property without due process of law. Do you think there is a gap in the law when it comes to the posting of election campaign materials in private properties? Because you cannot just consider, you cannot equate the use of private property with the use of a public place, and there seems to be no adequate guidelines in the law and in the rules.
Yes, actually, Your Honor. The Comelec Resolution 9615 is supposed to be an implementing rule and regulation to the Fair Election Act insofar as it is applied to the May 13, 2013 elections, Your Honor. But with respect to the posting of tarpaulins, Your Honor, or election campaign propaganda materials, with respect to this particular 2013 election, that supposed implementing rule and regulation merely duplicated the provisions of Section 9 without expanding the same, without actually explaining, or without giving us particular rules or guidelines on posting of tarpaulins on private properties when the same is done by private individuals, and the tarpaulin was given by a candidate, Your Honor. So technically, Your Honor, we can actually say that there is actually a gap in the law. However, Your Honor, this gap in the law, even if it exists, we have Section 9 of the new Civil Code, Your Honor, that even in case of silence or obscurity in the laws, Your Honor, this tribunal cannot renege on its obligation to settle this particular controversy. And if ever, Your Honor, there really is an ambiguity in the law, there are two possible interpretations, Your Honor. One interpretation would favor freedom because it would not be made to apply on private individuals, non-candidates, and non-members of political parties who exercises their freedom of expression within private premises. And on the one hand, Your Honor, implementing this, applying this to private individuals in private properties, Your Honor, will necessarily amount to to constricting the exercise of their freedom of expression. And so, with that, Your Honor, there can only be one direction that this court, can take, Your Honor, and that is a direction towards the expansion and giving more protection to this basic freedom, Your Honor.
Even if there is a gap in the law, the court will not shrink from its duty to balance the conflicting interests, the state interests for the fair and honest conduct of election, and the interests of private individual to property as guaranteed by the Constitution.
Yes, Your Honor. That is precisely the point, Your Honor. This honorable court can actually use the balancing of interest test, or, as in some cases, Your Honor, for example, in Adyong versus Comelec, it actually used the clear and present danger test. And we would like to submit to this honorable court that insofar as suppression and infringement of basic constitutional freedoms, like freedom of speech, Your Honor, the only test, or the test that should be used by this honorable court, is the clear and present danger test, Your Honor. And so with that, Your Honor, there is a heavy burden on the part of the Comelec and the state to establish that there is a substantive evil, Your Honor, that will be caused by the posting of these particular tarpaulins.
Okay.
So if the state cannot establish the existence of that evil, Your Honor, then this case, Your Honor.
Okay. Justice Bernabe.
Your Honor.
Counsel, all along, we're actually talking about two kinds of regulations. One is the content neutral and one is content based. Now, the Comelec claims that its regulation is content neutral because it merely affects the time, place, manner of speech according to well-defined standards. Now, you are claiming that it is content based because it affects the message that you are trying to impart. Now, there's a difference, of course, between the two. As you said earlier, when it is a content-based, you have the presumption of unconstitutionality.
Yes,
and therefore, the Comelec is duty-bound to prove the compelling interest of the state. While if it is just a content-neutral, you only have a substantial interest, which is, of course, the middle ground between the rationality of the law and the compelling state interest. Now, would you please tell us and explain to us how this content neutral can become a content based or affect your freedom of expression?
Actually, Your Honor, it is not actually a content neutral, and therefore it did not become a content based. From the very beginning, Your Honor, it was a content based regulation of speech, Your Honor. In the first place, Your Honor, this particular regulation would only apply to this particular kind or type of expression, which is related to the election. Now, if it is not related to the election, Your Honor, it will not be subject to this particular regulation, and this regulation would not apply. And therefore, it's not only about the size. This regulation would only apply because of the content of the poster or the tarpaulin. Now, if the size regulation has nothing to do with the content, then, Your Honor, for it to be valid, it must apply to all tarpaulins, regardless of the content, regardless of the type of the matter or viewpoint being expressed in the tarpaulin. Then it should apply to all kinds of tarpaulins. Then it would become content neutral.
We're just talking about the specific tarpaulin. How does the regulation of the size affect the message that you are trying to impart? Can you not put it on a 2x3 message? 2x3 size of the tarpaulin, and still be able to persuade the public about the message that you are trying to project?
No, Your Honor. Putting or lumping everything, this huge message of the diocese, Your Honor, if we will resize the tarpaulin and put this entire message of the diocese in only a size of only 2x3, it will be hardly visible, Your Honor, in people passing by, Your Honor, especially from the roadside. Either they are inside motor vehicles or only walking, Your Honor. So it will necessarily destroy the efficacy of the message, and necessarily, therefore, it will foreclose the exercise of freedom of expression.
Okay. Let's go to another point. I think important also, and this among the issues would be whether or not the tarpaulin is an election propaganda material. Would you agree with that?
Our contention, Your Honor,
because
is
if
that
it is, it would be subject to the regulation of the Comelec.
our contention, Your Honor, is that that would be irrelevant, Your Honor, insofar as applied to the petitioners in this case, Your Honor.
It would depend, of course, whether or not the material promotes or defeats or promotes the election or defeat of a candidate. And
Yes, sir.
in that connection, may I ask you the following questions?
Okay, Your Honor.
Now, apart from promoting the advocacy of the church, what other purposes do you have for the display of the tarpaulin?
Well, Your Honor, that is principally the purpose of the display of the tarpaulin, Your Honor.
Principally, but do you
Principally, Your Honor.
but any other purpose, whether incidental or
Well, it may be said, Your Honor, the incidental purpose, Your Honor, is really to make known to the public the stand of and the position of the diocese concerning the RH law.
Okay. Now, why do you have to print the names of the candidates and party list on the subject poster?
If the names of the candidates would not be there, Your Honor, it would be hard on the part of the public to remember the names of those who either supported or who opposed the RH law, Your Honor. And with respect to freedom of expression, Your Honor, it's part of the expression, Your Honor, putting the names of the candidates. And it's actually a matter of public concern, Your Honor. It's a legitimate matter of public discussion to discuss who in particular supported or who in particular opposed the RH bill. So we actually do not see anything wrong, Your Honor, with the listing of the names and putting them or printing them on the tarpaulin,
What
Your
does
Honor.
the check mark beside the Team Buhay really represent?
They are pro-RH law, Your Honor. They are anti-RH law, and therefore there is a check. Because the diocese, Your Honor, is anti-RH law.
Okay, and what does the X mark say?
These are the people, Your Honor, whom the diocese considered to be part of the Team Patay, Your Honor, and therefore, because of their stand on the RH law.
Now, what do you exactly mean when you say Team Buhay?
When I say Team Buhay, Your Honor, it's about the stand of the diocese, Your Honor, concerning the gospel of life.
And how about Team Patay?
It's the culture of death, Your Honor, as it's the term used, Your Honor, in some papal encyclicals, Your Honor, culture of death. And that is precisely, Your Honor, the language that was used by the tarpaulin, Your Honor. And it's also for purposes of part of styling, Your Honor, for purposes of making it effective, Your Honor, because that is the power of the expression, Your Honor. You have the choice of the language, Your Honor, is part of the expression. Had they used a different language, Your Honor, it would not have, attracted much attention, Your Honor.
Okay, Counsel, are you a registered voter?
Yeah, sure.
You are. Now, what effect does this tarpaulin have on you as a registered voter? If you see this tarpaulin?
Well, the message says, Your Honor, conscience vote. And therefore, I may take it as I'm being told by the diocese to vote in accordance with my conscience.
Would it influence your vote at all?
It may influence my vote to some extent, Your Honor, but as the tarpaulin says, it's conscience vote, meaning to say I can make my own independent judgment.
Thank you.
Justice
Thank you very much, Your
Garbio,
Honor.
and then Justice Leonen.
Counsel, you said earlier that the 2x3 regulation, the size of the poster, applies only to candidates and political parties under the Fair Election Law. Now, can you read section 13, the last paragraph of section 13 of the Fair Election Law?
I apologize, Your Honor. I have no copy with me in the podium now.
Okay. It says here, violation of this act and the rules and regulations of Comelec issued to implement this act shall be an election offense punishable under the first and second paragraphs of Section 264 of the Omnibus Election Code. It does not say that violation of this act by candidates and political parties. It's generic violation of this act. And in fact, this law is also directed to media companies. They are directed to give the right to reply. It's directed also to movie houses. They are directed not to exhibit certain films of candidates. So this law is not limited to candidates or political parties. It applies to the public. So why are you saying that only candidates and political parties are regulated by the 2 by 3 feet limitation?
What we are saying, Your Honor, is that is only insofar as Section 9 of the Fair Election Act is concerned, Your Honor, with respect to the posting of lawful campaign propaganda materials, Your Honor. The law only says candidates and political parties. So if we will read that in relation to the election offense, if we will read that together in relation to the election offense, Your Honor, that would necessarily have to apply only to candidates and political parties. And we are not also saying, Your Honor, that it doesn't apply to...
Read Section 9. That refers to common poster areas.
In particular, Your Honor, it says that the Comelec may authorize political parties and party list groups to erect common poster areas, Your Honor. And then there's another paragraph which says, Your Honor, candidates may post any lawful propaganda material in private places with the consent of the owner thereof, and in public places or property which shall be allocated equitably and impartially among the candidates.
Okay.
So,
because it says here candidates may post, you are saying that since only candidates are mentioned, other non-candidates may post without this limitation. That's what you're saying. In fact, you're saying that. Because there is no provision here which says the penalty shall apply only to political parties and candidates if they violate this law. There is none.
Well, if they would conspire, Your Honor, with candidates and then they would violate election law, then they would be covered. But insofar as a person...
I'm not talking of conspiracy. I'm talking of a citizen who violates the regulation in his own private property. You are saying he is not covered because the fair election law applies only to candidates and political parties. Where does it say here that it applies only to political parties and candidates?
Well, with respect to the posting, Your Honor, the paragraph is very clear.
That is your basis now. So your case will rise or fall on this provision. Because the moment we say that this provision does not mean that citizens, non-candidates, can violate the size regulation, then you don't have any defense anymore.
Our case will rise or fall, Your Honor, based on this court's characterization, Your Honor, of the extent of freedom of expression.
No, you're already saying
insofar as it is related to this particular provision.
But you are saying that, you're saying that the size of 2 by 3 does not apply to your client because your client is not a candidate. Okay, what if we say that this size regulation applies to private parties? Then your client is now covered by the regulation.
Yes, Your Honor.
Okay, so it will rise or fall on this provision. You submit that.
But we have another contention, Your Honor, is that would only apply insofar as it does not infringe on basic constitutional freedoms, Your Honor. So what you are saying?
Okay, as I said, the Comelec is not preventing you from saying anything in that poster. There's nothing. They said that you can put anything there you want, but keep it in this size. That is the position of the Comelec.
And that is precisely the problem, Your Honor, because we cannot keep it in that particular size.
Yes. So because you're saying, and your reason for that, your client is not covered by the fair election law because he's a private citizen, he's not a candidate.
Yes,
in other words, you're saying the fair election law on regulating the posters, the sizes of posters, airtime, does not apply to non-candidates and non-political parties. That's
yes, Your Honor. That is our position.
Okay.
One of our positions.
Now we understand each other. Thank you.
Just a few questions, Counsel. So this is political speech, correct?
You may say so, Your Honor, in relation
So
to the
if
election.
it's
So it may-
political speech, just yes or no would be
Yes,
fine.
Your Honor.
Yes. So if it is political speech, then it will have relevance as to the time when it is made and when it is where it is made.
Yes, Your Honor.
Precisely that is your argument, right?
Yes, Your Honor.
After the elections, will the tarpaulin still have some relevance?
Relevance, Your Honor, insofar as they are part of the campaign of the diocese concerning the RH law.
So even the candidates will still be there after the elections?
Yes, Your Honor.
Okay.
To remind the people that these are the
Team
people who
Patay
voted.
does not include Pinoy, correct?
It does not, Your Honor.
Yes. By the way, is Team Patay a parody of Team Pinoy?
No, Your Honor.
It came before Team Pinoy. And
The
Team
decision
Pinoy,
and the
Team
choice.
Pinoy was copied from Team Patay? No.
The decision, Your Honor, actually came much earlier
And
before
in
the
the
announcement
listing
about
of
Team
your,
Pinoy.
the persons under Team Patay and Team Buhay are only candidates that are running for this election, correct?
Senatorial election, Your Honor.
Yes, it does not contain individuals who have very strong arguments for or against the RH bill, correct?
Because the tarpaulin,
And
Your
your
Honor, is about
contention
conscience
is
vote.
that it is still not election propaganda. Is that correct?
Yes, Your Honor.
Okay. Now, in free speech theory, there are paradigms which we use, correct? And you mentioned Gitlow and Debs. Of course, these are very old American cases. As a matter of fact, these
Yes,
are
sir.
American cases, and I would say that our jurisprudence in the Philippines, written by many of the justices here present, are richer than the former opinions of Justice Black or even Oliver Wendell Holmes. That one paradigm is, of course, speech in a theater, and that's where clear and present danger comes from, right?
Yes, sir.
There is a paradigm of marketplace of ideas, correct?
Correct, Your Honor.
That everybody should be able to express so that we can arrive at the truth. Is that not correct?
Yes, Your Honor.
And if someone is given a megaphone in that marketplace, then that person, therefore, has a skewed opportunity as against the rest, correct?
If he owns the megaphone, Your Honor, and if he has the
In
right
other
to
words,
the megaphone,
then it
Your
will
Honor.
not really be a marketplace where everybody is free. And this is, I think, what Justice Del Castillo was saying, that there can be, if there's too much speech given to a powerful individual or institution, that it can drown out the speech of others. Is that not correct?
Yeah, but Your Honor, the purpose of the...
So is this not a compelling state interest too, to allow others to be able to speak if they do not have a megaphone? Like let us say, for instance, an institutionalized church that will say that if you do not do what we say, you are sinners. Is that not correct?
Well, in some way, Your Honor, but if I may be allowed to explain, Your Honor,
So a fundamental state interest can be the equalization of opportunities, right?
only equalization of opportunities,
Now,
Your Honor,
let's
but
go to
not
the-
providing everybody with a megaphone in a marketplace of ideas, Your Honor.
Precisely. Remove the megaphone.
No, not to remove the
So remove
megaphone,
the
Your Honor,
tarpaulin
but
that is very big and allow a very small tarpaulin that is also affordable to others. Is that not correct?
the equalization of opportunity in the marketplace of ideas, Your Honor, is not to force everybody to speak only with their bare mouth, Your
Osmeña
Honor.
versus
So if
Comelec and
you have,
MPC versus Comelec, precedents in this court adopted that particular idea, correct?
yes, Your Honor, but
Yes.
they were decided
Now, as a
also in
matter
the
of
80s.
fact, in the Constitution, it is very clear. Because if we focus too much on the American Constitution, we will miss out on certain provisions being pointed already by some of the justices a while ago. Like, for instance, Article 9, Part C, Section 2, 7. The interest is actually there. It says to minimize election spending, including limitation of places where propaganda materials shall be posted. Isn't that a compelling constitutional state interest? To minimize
it is, Your
election
Honor.
spending, including limitation of places where propaganda materials shall be posted.
It is, Your Honor, but only up to the
Now,
extent
in the
that...
Constitution, does it say in this part that it will only apply to political parties and candidates?
No, Your Honor, but the power given to the
Thank you.
Comelec... May I be allowed to
Yes, sure,
explain,
sure,
Your Honor?
sure.
Yeah, Your Honor. But our point, Your Honor, is that the power given to Comelec, Your Honor, as explained in the case of Sanidad versus Comelec, Your Honor, with respect to Article 9, subparagraph C of the 1987 Constitution, the evil sought to be prevented, Your Honor, by this provision is the possibility that a franchise or a permit holder would favor or give any undue advantage to a candidate in terms of advertising space or in terms of radio or television time. So as long, Your Honor, as
This was in Sanidad.
in
What
Sanidad
about
versus
in
Comelec, the
N-
1990,
in
1919,
National Press, NPC versus Comelec.
the
and
NPC was
Australia
decided
versus
in
Comelec.
1981, Your Honor. Sanidad was decided in 1990.
About the later case of SWS, etc., where this court has adopted the idea of equalization of opportunities.
Yeah, Your Honor, but only insofar as it does
What
not
is the
infringe
interest
on
again of
freedoms.
limiting the size 2x3 for political candidates?
I didn't get that, Your Honor.
What is
Pardon?
the compelling state interest for limiting the size for candidates?
I do not see any compelling state interest, Your Honor.
Just counsel? Okay.
Your Honor.
Just a few questions. You're finished, Justice Leonen? Can you please refer to Article 10 of the Omnibus Election Code? Campaign and election propaganda. Now, this is the most comprehensive list of what can and cannot be allowed during the campaign period, including the prohibition against conducting campaigns prior to the entry of the campaign period. Okay. In Section 70, when you come to the term on definitions, you have a copy of the Omnibus Election Code?
I
with
have
you?
no copy, Your Honor.
Okay. You come to Section 79B, and it refers to election campaign and partisan political activity, and you have a enumeration of matters there. Now, you have Section 80, prohibition against the conduct of an election outside of the authorized campaign period. Okay. You have intervention of foreigners. You have Section 82, in Section 81. In Section 82, you have lawful election propaganda. In Section 83, it is about the prohibition against the removal, destruction, or defacement of lawful election propaganda. In Section 84, there are requirements for published or printed election propaganda. Then in Section 85, you have prohibited election propaganda. Then in Section 86, regulation of propaganda through mass media. Then 87, rallies, meetings, and political activities. And then you have public rally. And then 89, transport, food and drinks. And then all of those sections actually cover even the activities of private individuals.
Yes, Your Honor, but
Correct?
they do not violate freedom of expression, Your Honor. But as soon as there's a serious allegation that they
So
do violate,
what really is the issue here? Earlier, I thought the issue was your client cannot be covered because he is not a candidate. Neither
And
does
in
he belong to a
addition, Your
political
Honor,
party. Okay? So, we are saying here that the Omnibus Election Code clearly covers for many provisions, including lawful election materials, covers the activities even of private parties. Now, you're basically now saying, yes, my client can be a private party, but the moment that it talks about protected speech, which is the freedom to exercise one's religious conscience, then even Article 10, which enumerates so many prohibited and allowable acts of private parties, cannot apply to your client. You're basically saying, actually, that the right of your client is absolute.
not
Because
necessarily,
there is nothing here, therefore, that can touch your client anymore. Is that the moment?
Not necessarily, Your Honor.
The moment that it is a matter of faith, the moment that it is a matter of religion, then that is absolute. Even if the regulation is just about when your client can talk, what size the materials can be.
Well, Your Honor, if I may be allowed to explain.
Yes.
In the hierarchy of values, Your Honor, when we talk about a thought,
Okay.
a thought or idea, Your Honor.
You have already discussed sufficiently the hierarchy of values. And I understand that. But remember, we were very sensitive about also looking at state interests and
Yes, Your Honor.
respecting the rights of your client. So far, the questions have propounded been propounded and have largely focused on only one question. Can the Comelec not really have any right to regulate what your client wants to put up simply because you are already invoking it as an ecclesiastical matter, even if it's just a matter of size, and even if it's provided for in the Constitution and in the Omnibus Election Code? In other words, are you basically saying any private person who says that this is a matter of religious belief is beyond the regulatory power of the Comelec?
Provided, Your Honor, it is a valid and a genuine religious belief, and therefore there's a proper...
How can the court go into that? That's the problem here. You're basically asking us to judge the faith of the Bishop of Bacolod, and we cannot. But what is clear to us, from your own words, is that the listing of the names can influence votes. So now we look at the law, and it says if it promotes the candidacy or if defeats the candidacy, then it's considered as election material. So if it's election material, the next question is, can we not allow the Comelec to regulate the size? And you say, no regulation can apply because it is a matter of religious belief. So to what extent then can the state ever regulate an action that is considered as influencing the outcome of an election when the action is invoked as being born out of a religious conviction? Is there no space for regulation by the state on that matter? Considering that this is not about content, but this is just about the size.
In answer to the question, Your Honor, I would like to make a distinction between first a thought or an idea. A thought or an idea is absolutely protected because of the principle on freedom of political thought. Now, when that idea is communicated or expressed, in some way, Your Honor, the state may subject the expression of that idea insofar as it involves action. It may in some way be regulated by the state. Now, if it is purely action, detached from any idea or any thought that is protected by the Bill of Rights, then of course, it is subject to the full regulation of the state. Now, what we are saying, Your Honor, is that the size of the tarpaulin, Your Honor, is part of the expression in this case, Your Honor. As part of your freedom of expression, Your Honor, if it is a protected freedom, Your Honor, you have the right, and it is part of your freedom to decide how in the world you're going to express and communicate your thoughts.
So how large your communication is, even if your communication affects the outcome of an election, cannot at all be regulated. That is your point.
But the problem is, Your Honor, is
from a religious belief.
The problem, Your Honor, is...
So you're basically asking us also to review the entire chapter on Article 10 of the Omnibus Election Code, because we have to put all kinds of colatilia there.
Well, but actually that is not part of the issues in this case.
No, but if you look at the activities there, any private person can claim religious conviction.
Well, if there would be a proper case of controversy that will reach this court with respect to those particular provisions,
because
then...
Your theory is quite global in sweep. In other words, it is founded on the adhering to a belief that your client, simply because he is invoking religious belief in this matter, the size of his material cannot even be regulated. That's the plain argument that you have been making all this afternoon. Now, you look at Article 10 and you look at so many regulations on the behavior of private individuals. And we need to be convinced that the ones we give in to your argument, we are not sweeping the entire regulatory mechanism of the Comelec here. You understand the implication?
We understand your concern.
That's why we're trying to focus the question on whether is it so unreasonable for the Comelec to just regulate the size of your poster. And you have already concluded vehemently it is unreasonable for any size regulation to be imposed. So you adhere to that?
Yes,
and may I ask you to, in the memorandum we will be requiring you to assess the implication of your statements that have been made here this afternoon on the entire regulatory powers of the Comelec under Article 10 on regulation.
We are ready to do that in our memorandum.
Okay. So with that, we can go to the respondents. Thank you.
Thank you very much, Your Honors. May it please the Court.
Please commence, Solicitor General.
If Your Honors please, in obedience to the advisory of this Honorable Court, we will address the issues briefly one by one. To answer the first question of this Honorable Court, we respectfully submit that the assailed orders and notices are not final orders of the Comelec and Bank, and therefore are not amenable to review by this Honorable Court. And we cite the cases of Ambil and Cayetano versus Comelec. Your Honors, let me dwell a bit on a second point. Petitioners have also violated the principle of exhaustion of administrative remedies. Under the Comelec's rules of procedure, where there is a colorable violation of, for example, restriction on campaign materials, a private party may, or the Comelec motu proprio may, initiate an investigation into whether or not an election offense has been committed. The Commission may refer the matter to its law department, which may delegate the matter to an election officer. The election officer will investigate, and if he or she finds that there is no violation, that will be the end of the investigation. However, the election officer, if he finds there is cause, may hold a preliminary investigation, subpoena the respondent, call for the submission of affidavits and counter-affidavits, and even call for an evidentiary hearing. The law department shall then review the recommendation of the legal officer if he or she finds a violation and prepare a report and recommendation to be submitted to the Commission and Bank. If the Commission and Bank approves the filing of an information in court, the law department shall sign the information. The rules of procedure of the Comelec expressly allow for judicial review conformably to the rules of court and the Constitution. We submit, Your Honors, and we'll go back to this later, that here petitioners did not exhaust these administrative remedies available to them. In reply to question 1A, we also respectfully submit that the petitioner submitted the hierarchy of courts. This is a petition under Rule 65, and petitioners could have filed a petition with the lower courts which have concurrent certiorari jurisdiction with this honorable court. So we come to a very important point, Your Honor, in answer to your question number 1B. We respectfully submit that petitioners have not shown the existence of exceptional circumstances that will warrant a direct resort to this honorable court. To the extent petitioners assert rights under the freedoms of speech and of expression, the issue raised is, we concede, important, but the resolution of such issue is ground previously much covered already by this honorable court. In fact, if we may, thrice definitively covered by this honorable court. In the cases of National Press Club versus Comelec and Adjong versus Comelec in 1992, and in Osmeña versus Comelec in 1998. In those cases, this honorable court already held that the constitutional power of the Comelec of supervision and regulation of the enjoyment or utilization of, among others, media of communication during the election period may result in some, and I stress this is the word of this honorable court, may result in some limitation of speech. What is novel about this present case is only whether the limitation of the size of the poster, which as this court has noted this afternoon, has been prescribed by Congress under the Omnibus Election Code in Section 82 and as adopted by the Comelec in its rules, Resolution 9615. The question is whether the maximum size prescribed, which is 2 by 3 feet, is a reasonable limitation. Novel and important as that question may be, we respectfully submit that the method to be followed to resolve this particular question was already laid down also by this Honorable Court in the National Press Club case. Since, and as this Honorable Court has noted this afternoon, since the limitation on speech is allowed by the Constitution itself, no presumption of invalidity can arise from the exercise by the Comelec of its supervisory and statutory authority. Thus, Section 82 of the Omnibus Election Code and Comelec Resolution 9615, according to this Honorable Court, are presumed to be constitutional. Petitioners, as the parties effectively asserting their unconstitutionality, are the ones who must discharge the burden of clearly and convincingly prove their assertion. And with all respect, we submit those assertions petitioners must prove at an administrative hearing were one to be made by the Comelec should it decide to prosecute an election offense. To quote again the method prescribed by this Honorable Court in National Press Club, the question presented is whether the requirement of a 2 by 3 feet maximum is, and I quote, outside the permissible bounds of supervision and regulation, end of quote. And there being a presumption of validity, as this court held in the case of Ermita Malate Hotel and Motel Operators versus City of Manila, and again quote, the necessity for evidence to rebut is unavoidable, end of quote. The triable question of fact then to be determined at such an administrative hearing is whether or not the 2 by 3 feet limitation is unreasonable as to violate due process of law. And if I may, Your Honors, at this point, inject, in an administrative hearing, if one is held and if the Comelec decides to prosecute, the cost of the poster would be a matter of interest and should be presented and examined in evidence. We ask around, Your Honors, and in Manila, a poster, a full color poster size 2 feet by 3 feet will cost 240 pesos, 240 pesos. A 6 feet by 10 feet full color poster would cost 2,140 pesos, 2,140 pesos. Or, if Your Honors please, the cost of a 6 by 10 is approximately 10 times the cost of a 2 by 3. And herein lies the burden of the petitioners. In an evidentiary hearing, they bear the burden of proving that the 2 by 3 size is unreasonable. But going now to the objective of the Constitution, which is to level the playing field in the marketplace of ideas, then certainly it should be considered by the trier of fact that indeed one justification for the 2 by 3 is that even in present peso terms, one objective is that a 240 peso means of communication is available to a candidate or to a person giving the same message and will be at a full disadvantage against another person who has more resources, who can afford a 6 by 10 feet poster or tarpaulin costing more than 10 times. And as this Honorable Court also said in the case of Ermita Malate Hotel, as underlying questions of fact may condition the constitutionality of legislation or administrative rules of this character, there is indeed a need for some factual foundation of record to support any overthrowing of a statute or of an administrative rule. We respectfully submit that such factual foundation petitioners should, if they wish, first build in an administrative proceeding if one is filed, if a charge is filed, and then they should allow the Comelec and bank to act by final order, and then, and only then, if they are not satisfied with that final order, can they resort to this Honorable Court. Petitioners also assert or seem to assert a constitutional right to display a 6 foot by 10 feet poster, invoking, and I quote, a right and privilege of the Church to propagate and spread its teachings, end of quote. And petitioners also assert that they do so because their act of calling its members and followers not to support candidates they have identified as anti-life and to support candidates they have identified as pro-life is, again, to quote petitioners, inextricably connected to its Catholic dogma, faith, and moral teachings, end of quote. These present two questions, Your Honor. The first one, whether or not speech uttered by the religious in support of or in opposition to the election of a candidate in an election is entitled to the same constitutional protection afforded the same utterance made by a non-religious. Second, this issue presents the question of whether or not the speech being claimed by the petitioners is a species or category of speech that is entitled to more, or is it the same, or is it less, protection vis-a-vis secular restrictions on speech during the election period, as allowed by our Constitution. Your Honors, certainly these are important and very novel questions. But again, we respectfully plead with the Honorable Court and respectfully submit that the resolution of these issues would be best deferred until after a factual foundation of record is built in a Comelec administrative proceeding. It seems to us, with all due respect to the petitioners, that petitioners' unarticulated argument under this second leg of their petition is to carve out an exception to the 2 by 3 feet maximum poster rule under the free exercise clause of the Constitution. If such be the case, then we respectfully submit that the teachings of this Honorable Court in cases such as Austria versus NLRC and Escrada versus Escritor is that, again, petitioners should first present before a Comelec hearing evidence on such important triable questions, the foremost of which would be whether or not or how the decision of the petitioners to support or their decision to oppose a candidate is, and I quote again, inextricably linked or connected to dogma, end of quote, as to be arguably constitute speech partaking of perhaps what we call speech of an ecclesiastical character, as to be beyond the reach of non-content secular regulations on political speech allowed by this honorable court under the analysis of National Press Club. As to question number 2, Your Honors, we respectfully submit that it is relevant to determine the subject, whether or not the subject tarpaulin is an election propaganda. However, with all due respect, I believe this has been much discussed this afternoon, and we will cover this more in our memoranda if the court will permit. We may only cite, Your Honor, that no less than the petitioners themselves make judicial admissions. In paragraph 37 of the petition, they say that the RH law gains relevance in the exercise of the people's rights of suffrage, or in other words, it's relevant to the elections. In paragraph 45 of the petition, they have declared that they have called on their members and followers of the church not to support any candidate who is anti-life and to support those who are pro-life. As to the question number 3, Your Honors, we respectfully submit that the subject tarpaulin is an election propaganda, and yes, of course, it is a form of protected speech. We repeat only that, as this honorable court has said in National Press Club and Osmeña, it is protected speech subject to limitations. And these limitations take the form of a reasonable time, place, and in this case, manner, in addition to its being a non-content restriction. Finally, Your Honors, may we be allowed to answer together your questions number 4 and 5. We respectfully submit that on the part of the Comelec, there is no violation of the principle of separation of church and state, because the Comelec, by all its actions, has not intruded into the religious affairs of the petitioners. In like manner, we concede there is no violation of the same principle on the part of petitioners, because a citizen, whether or not he belongs to or supports the religious, is entitled to express his views on political matters. However, in doing so, he or she must comply with the limitations provided by law. Again, our position, Your Honors, is petitioners are entitled to express their support for or against any candidate in the exercise of the right of freedom of expression. However, in doing so, they are subject, as all citizens are, to the poster-size regulation laid down by Congress and the Comelec pursuant to the Constitution. Thank you, Your Honors.
With your permission, Chief. First, the procedural situation. So, what we have here, as we read the petition, is that the petitioners are not questioning the validity of the law or the regulations of the Comelec, but would you agree with us that it is with respect to the application on them of the law and the regulations of Comelec?
That would be correct, Your Honor.
And just to clarify, the facts here are not contested. In other words, there is an acceptance by the petitioner that their tarpaulin is beyond the 2x3 limitations of Comelec, and that too is posted in a church wall, and that church is definitely not owned by the public.
Yes, Your Honor.
And just to clarify, with respect to our Bill of Rights, there is always a presumption that our Bill of Rights are to be enjoyed, such as, for instance, freedom of expression, and whatever curtailment there are or burdens, whether incidental or fundamental, must be justified. It is not freedom of expression that is justified, but the burdens on expression which should be justified. Is that not correct?
We agree, Your Honor.
Okay. The next point would be on the right of suffrage, that it is not only the right to vote, but it is to have a meaningful vote. Would you agree with us?
We agree, Your Honor.
And a meaningful vote, therefore, should also mean an informed vote by the public. Is that not correct?
We agree, Your Honor.
And that we should not simply allow only the candidates to define the terms of the debate, but that the private sector itself, the people that will actually vote for the candidates, can also define the terms of the election, the terms of the issues, and many other considerations for electing a candidate. Is that not true?
We agree, Your Honor.
So, in a sense, would you recall if there is any case that has expanded on the concept of the right of suffrage in relation to freedom of expression from this court?
I cannot, Your Honor.
Yes, and it appears to be one of first impression, because in this particular case, the issue has been driven by the Diocese of Bacolod, regardless of whether we agree with the manner and the thought that is involved in the concept of Team Patay. Some may consider it to be a bit beyond the Christian doctrine of being charitable to others, but still it is an issue which has been defined by the private sector, not by a political candidate. Would you agree with us?
I agree, Your Honor.
And wouldn't you think that that is something to be celebrated and protected? And therefore that we should try to read into our election code the ability of our publics to be able to raise these issues and encourage them rather than curtail their excitement, their motivation, and their style of being able to put this across.
We agree, Your Honor, but the excitement and motivation should be canalized in the case of posters, now called tarpaulins, within the 2 feet by 3 feet limitation, Your Honor.
Okay. Political candidates use their faces and their names in order to campaign. So, would you agree with me?
Yes, Your Honor.
And sometimes, of course, they use the faces of others, like celebrities, among others. Is that not correct?
Yes, Your Honor.
And for the public in general, of course, if we want to alter the terms of the debate in political exercises like what we are going to have in May, sometimes a 2 by 3 poster would require more text rather than faces. Is that not correct?
That is correct, Your Honor. That's why we are... Our position is whether 2 by 3, which seems to have been laid down in under the old code, 20, 30 years later, is still reasonable, is a matter of opinion, and in a court of law, a triable question of fact. How much message can you squeeze into a 2 by 3 as against a 6 by 10? Obviously, you can squeeze in more message. But under the fact, Your Honor, the size of the fonts were that, the same message could have been put into a 2 by 3. Now, as to the visual impact, again, this is a triable question of fact. In an age of tarpaulin clutter, an argument can be made that perhaps 2 by 3 is not sufficient anymore. But whether it is constitutionally required is a matter, I would submit, for the Congress to debate. And in the case of a challenge, the burden would be on the petitioners to say why it is now unreasonable, Your Honor.
Yes. Again, we go back to the presumption that that freedom of expression is to be presumed, and any burden should be explained, whether that burden is incidental and allowable because it is reasonable, or fundamental. So it is not the opposite. So, for instance, that a certain individual thinks that a very big poster with very few words will have that impact. Of course, you would agree with me, for instance, that the Nike symbol, the check mark, put in white space, put in a very big poster, means a lot of things. Or for that matter, in generations ago, you would have the Beetle, which is the Volkswagen, and only one word, it said lemon. And that already spoke volumes about the message that was there. But we leave it up to the speaker to be able to make the speech in the way that they want it to be spoken, and therefore it is the other side, the burden, which we should explain. Would you agree with me?
Well, may I respectfully disagree, Your Honor, because I agree with the general propositions you have laid out as a matter of the law on freedom of speech. But in the particular case of our Constitution, and as this court said in National Press Club, during an election period, and this is where the court explained that the general principles, for example, of freedoms in the American Constitution do not apply, because in our case, it is our Constitution itself that put that limitation. Of course, only during the specific and limited period. That is why the general principles of free speech during the election period, according to this honorable court, are quite different. And in fact, the court said in reply to the argument that then it is the state that has the burden of proving clear and present danger, that is not the teaching of this honorable court, Your Honor. In National Press Club, it very clearly said, since the burden is imposed by the Constitution itself, the traditional rules of the state explaining away the burden and whether it is through clear and present or compelling state interest do not apply. In fact, this court very clearly said it's not compelling state interest. The issue is whether or not the regulation, in this case 2/3, is reasonable. And that flows from the fact that the impingement on speech, as the court said, there is some impingement on speech, has been imposed by the Constitution itself.
But would you say that there is a difference in those cases that was mentioned by the Honorable Solicitor General, that in those cases what we were dealing with was limited media? In other words, newspapers have just enough space. Radio has bandwidth, for that matter. And therefore, the question there was the allocation of space. But in this particular case we have now, this is more like the case of Adyong, where the question was whether decals could be put into private cars. As a matter of fact, there were words in the case of Adyong which actually said that it may have been produced by a candidate, but if somebody, a private person, takes that decal or sticker and puts it in the car, it becomes his speech. And the Supreme Court in that case, very clearly, we have ruled that that is beyond the scope of regulation of the Comelec. So we have here speech that is not subject to space because it is up to the private person to use their private spaces. Whereas in NPC and Osmeña, which by the way were very divided courts, it was limited media.
Again, if Your Honor please, I beg to respectfully disagree. I find no distinction between the circumstances in National Press Club. Indeed, in that case, it involved radio and television ads. And indeed, in radio and television, there is a limited spectrum. And indeed, in the case of posters, there is no such limitation. But again, I go back, as this court so clearly held in National Press Club, this all goes back to equalizing the marketplace of ideas. To follow the example of the Honorable Justice, the megaphone, which is an equipment only afforded by the rich, the analogy would be the 6x10, which only a more affluent person, religious or not, can afford to the pop of 2,140 pesos versus a 2x3, which will cost only 240 pesos. As to how much message you can cram into a 2x3, again, Your Honor, using the analysis of this Honorable Court in National Press Club, we should not forget that the election law gives political parties and candidates and plain citizens exercising the right of speech alternatives, Your Honor. The alternative to a poster would be a written tract, whether mimeographed, Xerox, or photocopied. But again, If a candidate or a citizen takes the track, again, there is a limitation. I think it's 8 by 11. My point is there are alternative modes, Your Honor, and the whole idea is to control spending. And so you go back to the electoral reform, Your Honor.
On the other hand, when elections reduce individuals to atomize individuals, when elections reduce the electorate to atomize individuals, that disempowers them. But a megaphone can be bought not only by an institutionalized church, but it can be bought by a political party that organizes. It can be bought by an advocacy group that organizes. And therefore, the louder your voice, it is also dependent on your ability to be able to become a collective. And therefore, that too can go into our free speech theory. But nonetheless, maybe just a couple more questions. Was Adyong a facial challenge? Adyong versus Comelec?
Yes, Your Honor.
Okay. And every act that we do is, can we say that it is equivocal in the sense that our acts, and this is in the form of behavior, can be accompanied by moral judgment on the one hand, and on the other, it will have a secular purpose, such as, for instance, that we vote for the RH law, when in the sense of members of the House and the Senate, can be seen as an act with a secular purpose, which is to actually produce information to the public, but it will also accompany with it a sort of a moral judgment from the point of view of the faith of that individual. Therefore, if every act is equivocal, which one should dominate in terms of the interpretation of this court?
Can I address it, Your Honor, in 2 points? First, on the facial challenge in Adyong, and I would repeat, the reason there cannot be a facial challenge in this case is that this Honorable Court already said the National Press Club, the regulation is mandated, allowed by the Constitution. Therefore, the regulation cannot be unconstitutional on its face. The only time it can be unconstitutional is after a trial, the petitioners can prove that 2 by 3 is unreasonable. But you cannot, on the face, come to a conclusion bereft of a factual foundation why 2 by 3 is unreasonable or why 8 by 6 by 10 is the new norm in 2013. Those are matters of choice for the Congress to make in the first instance. But, Your Honor, it is within the purview of the impingement of speech provided for by the Constitution. As to the second point of Your Honor, yes, indeed, there can be equivocation on both sides. But, again, you cannot stop the regulatory agency if, in the view of the regulatory agency, a position being put forward as a matter of faith has the result of influencing an election, then the regulatory agency can take a position and bring a prosecution, Your Honor. But again, I would propose to the Honorable Court that the impact of the words, for example, one of the justices had asked, the impact of the words, the impact of the check, the impact of the placement, these are all triable questions of fact, Your Honor.
Describe you.
Counsel, you cited in your memorandum, in your comment, Section 4, Article 11, I think, Article 9 of the Constitution.
Yes, Your Honor.
On the regulation of companies who utilize or use franchises and permits. Okay. This provision of the Constitution, Section 4, is self-executing, correct?
Yes, Your Honor.
It authorizes the Comelec to regulate companies that have franchises or permits and engage in media, transportation, etc., correct?
Yes, Your Honor.
There is no need for statutory law for this.
We agree, Your Honor.
And this provision, however, requires that the parties or companies regulated must have franchises and permits from the government, correct?
Yes, Your Honor.
So you are talking here of television, which requires a franchise, radio, which requires a franchise, transportation companies require a franchise. But this will not cover newspaper, correct? Because you don't need a permit to operate a newspaper.
Not in that sense, Your Honor. Although, as we know, the law and the Comelec have also put on size limitations.
Yes, I know. But as far as this provision is concerned, it speaks of the power of the Commission, Comelec, to supervise during election period the utilization of all franchises or permits. So you must have a franchise or a permit to be regulated by Comelec under this section, correct?
Yes, Your Honor.
And newspapers don't need franchises or permits to operate. That's part of the freedom of the press, correct?
Yes, Your Honor.
Okay. But this provision is not really the provision of the Constitution that is at issue here, that is being used by the Comelec, because we're not talking of franchise or permit here. Where the provision that the Comelec is using, provision of the Constitution, is really Section 2, Paragraph 7 of Article 9, which refers to the power of Comelec to recommend to Congress effective measures to minimize election spending. Correct?
We agree, Your Honor.
Okay. So this is really about minimizing election spending and not ensuring equal time, opportunity, and space under Section 4. This is more on Section 2, Paragraph 7. Correct?
We agree, Your Honor.
Okay. Now, so the Congress passed a law. It's in the Fair Election Law. It's in the Omnibus Election Code that the size of the poster must be 2 by 3, no more. Correct?
Yes,
2 by
Your Honor.
3 feet. Okay. So if you are a candidate, you can print several posters 2 by 3 feet with your name, vote for, etc. One person only, and you can post it on the wall of your house, correct? Facing the street.
Yes, Your Honor.
And you can also post another one, not only one, a poster, 2. Can you do that? There's no prohibition.
There's none, Your Honor.
So in fact, you can plaster your entire wall with the same 2 by 3 poster saying vote for you, correct?
Yes, Your Honor.
So where is the rationale there? I mean, you're not really limiting election spending here because you're saying 2 by 3, but you can put it regardless of the number on the same wall. There's no requirement that there has to be a distance of 10 meters before you can put another poster.
Well, if I may hazard a explanation, Your Honor, as you say, it is to control election spending. And the equalizer, I think, in that case will be that the wealthy is limited to a particular size, so that to that extent and to an extent possible, there is some equalization, but not a perfect one. And of course, nothing will prevent a wealthy candidate from having 100 posters grouped together.
Okay, so it looks like it does not really limit election spending. Now, when you put the poster on a wall or in a tall building and you want it to be seen by the motorist, it must be of a certain size. The font must be big enough to be seen from the street, correct?
From the point of being...
but since the Comelec said you cannot exceed 2 by 3, this is in effect, the Comelec is saying you have to make do with the font that will fit the 2 by 3 poster, correct?
That's right, Your Honor.
So it looks like that's probably good only for one name, one candidate, and then you put it on a tall building that can be seen. So would you agree with me that this limitation of 2 by 3 refers to per candidate?
That could be a reasonable interpretation, Your Honor.
So the Bishop of Bacolod can put one 2x3 poster of X candidate, another 2x3 poster of X candidate, and so on. Or he can put 2x3 poster of the same candidate, and there's no problem with that. Correct?
That could be, Your Honor.
So, if you are allowed to do that, why can't you be allowed to just put up a poster of 6x10 and you put there about 10 names or 12 names? If you come do the math, it will be 2x3 per candidate. I mean, why can't you do that? It will save money because you print it only once.
My answer, Your Honor, would be, again, the regulatory scheme is not perfect, but if you go back to the purpose of equalization, certainly a candidate who can only afford one poster and has only 240 pesos can print one, and the wealthy candidate is forced to go by a 2x3. Now, certainly the wealthy candidate can afford maybe 1,000, whereas the not wealthy candidate can afford only one. But that's in the nature of that's as far as the Constitution can go, Your Honor, as also expressed in National Press Club. It is not perfect, but that's the regulatory scheme that the Congress put forward.
Okay, supposing now the Bishop of Bacolod will put a poster which has 10 names, and it will be 10 times 2x3 in size, 10 times, with 10 names. Will that be in violation of the Comelec rule? With all due respect, Your Honor, may I be allowed not to express an opinion, because I think the example of the good justice is if there is a montage, say a 30-story building, and then you cut it down to size, but the effect is one visual representation, whether the picture of a candidate or the names of the candidate. I would let the Comelec first, with their expertise and experience, let us
respond.
Say that, let us just assume there are 12 names in one poster of the bishop. 12 names. Team Patay, 12 names. And if you do the math, you divide that area of the poster by 2x3, it will amount to one name per 2x3. But instead of running this several times, it will just be a one run of the printing machine. So he will save money. Will that violate the regulation? Because the idea is there, one name per 2x3 feet.
Again, Your Honor, with respect, I would respectfully beg off, because there will be a visual impact, a visual impact of a stack of 12 names, which will cost more as compared to the visual impact of so many names squeezed into a 2x3.
Yeah. I think nobody will put up a poster of 2x3 with 12 names and put it in a wall. Nobody will see it. So you have to put one name per 2x3. That's the area for the name, so that the font will be big enough. So if you put 2x3 per candidate, there will be no problem because they are cut separately. But you will have to make several runs in the printing press. So in order to save money, you will have a one run and put all the names there, but the size is still 2x3 per candidate. Will that satisfy the requirement of the law?
Again, Your Honor, I respectfully beg not to answer the question, because if I understand it, a reasonable person can argue that that is an indirect violation.
Yeah,
because you are allowing somebody with more money to have a bigger poster in the guise of having 12 2x3s. Is certainly a larger poster, will cost more and have a bigger impact, Your Honor.
Yeah, okay. Thank you, Counsel.
Counsel, I Assuming that the Diocese of Bacolod focuses on only one candidate that was so vocal and who was responsible for swaying the House of Representatives and so much of his or her colleagues to voting for the RH bill, and they focus on him and him alone, will the argument be the same as you had heard it earlier on the right of the freedom of religion to be exercised in this case when there is only one candidate as against when there are multiple candidates? Could you see any variance that would affect their argumentation, considering that this entire afternoon they were just focusing their arguments on the matter of who belongs to a team patay or a candidate who is being the focus of discouragement, address the voters, the exemption being that is a purely ecclesiastical matter. Do you think the legal argument will be affected in any way?
I would not think so, Your Honor, because our position is certainly it is within the right of a religious to express a political view. And whether they choose 1 or 12 to support or vocally not support or argue not to support, I believe would be within the realm of the church or the denomination.
Would it be within the factual competence of the Comelec to determine really the costing for the sizes of the tarpaulins, which will go into their economic calculation of what equalizes and what does not equalize?
Our submission, Your Honor, is the costing would apply, assuming the petition is founded on an argument of pure political speech. But the same would apply even if, in our submission, the right is founded on freedom of conscience or freedom of religion.
So, actually, my question is it really within the competence of this court on these matters to focus on what would make sense or not as a matter of policy on the part of the Comelec?
Only to the extent, Your Honor, that there is a secular policy of the Constitution to equalize, and there is a secular policy of the Congress to effectuate that constitutional objective through a limitation, Your Honor.
To what extent can the Comelec really distinguish between a material that affects a vote for or against a candidate? In other words, there was a statement earlier propounded by the petitioners, but that was just a continuation of their advocacy against the RH bill.
Well, I think...
And they were not that clear that it would definitely affect the votes of individual registered voters.
Well, that is, with all due respect, Your Honor, that is a claim, that is an assertion. At the end of the day, a judge or an administrative body will have to make a decision based on the facts. Our proposition is, if you have a poster which says, check, this is election time, you are a church, you are opposed to this law, you are singling out, naming those who supported and those who did not support, a judge could reasonably come to the conclusion based on the facts and the law that indeed that is election propaganda, Your Honor, designed to affect an election.
Can the Comelec see an election propaganda the moment its officials see one? In other words, is the legal standard for determination of what a propaganda material is or not the same manner by which you determine whether a material is obscene or not?
I would submit so, Your Honor, because the classical, this is a case of first impression, but the classical election propaganda would be, there's a name, there's a logo, there's a political party, and indeed in the experience of the Comelec, they will see whether 1 is 2 by 3 or more. Now, this is the case. This petition presents particular problems because it is not your typical 2x3. It's not your typical election poster, Your Honor.
Okay. Justice Peralta has a question.
Just 2 or 3 questions, Chief. Can you tell us why you consider the tarpaulins election propaganda?
Because, Your Honor, they are...
what makes the tarpaulins election propaganda?
Because the net effect, Your Honor, of the words, the text, and the visual impact is that they support candidates who voted against the RH bill, Your Honor.
Supposing you remove the words conscience vote, and what would remain would be the members of the Team Buhay and Team Patay. Would you still consider the tarpaulins election propaganda?
Again, Your Honor, a reasonable judge could arrive at that conclusion. That
it is merely a listing of those who are in favor of the RH bill and those who are opposed, without telling to the members of the church to vote for the Team Buhay.
Considering, Your Honor, that there is an election contest, going on, and the sectors of the church have been very vocal against it, and just naming the names, Your Honor, a reasonable judge could come to the conclusion, again, as I said, that indeed that is put up to seek to persuade or affect the decision of a voter, Your Honor.
But they're only telling the truth. These are the members of Team Buhay and these are the members of Team Patay, without campaigning for any of those listed in the tarpaulins.
You're right, Your Honor. But again, as I say, a reasonable judge or an administrative agency can come to the conclusion that in the context of that time, the period in which that is made, the position of the petitioner as a member of the church, that the tarpaulin was put up as a way to persuade a voter to take a particular position.
Supposing they include names who are not candidates. In the Team Buhay, they will include names who are not candidates. They are not running for a public office. Your answer will still be the same?
Arguably, Your Honor, if they are the same font, there can be an argument made. But again,
that's why I'm saying the same font. They include other names who did not vote or who are not running for a public office in the 2013 elections. Your answer will still be the same?
Again, the administrative agency can still arrive at that conclusion, Your Honor. Because
what would be the basis?
The basis would be the additional names were put there as a way to blunt a conclusion, Your Honor.
Do you think you would be stretching too much the meaning of election propaganda? What I understand of election propaganda is that you campaign for certain candidates. The names there are not candidates, so how could they be campaigning for persons who are not candidates if they are listed in the tarpaulin?
Again, Your Honor, the administrative agency can come to a conclusion that what cannot be done directly cannot be done indirectly, and the fact of putting additional names is, probably will dilute the message. But again, a reasonable judge can arrive at the opposite conclusion, Your Honor.
Okay, that's all.
But
you said, and I'm impressed with that the whole idea is to control election spending. Is that right?
Yes, Your Honor.
So in fact, you mentioned that the 2x3 poster costs about 240 pesos, so it's cheap, and even the poor candidates can probably afford it.
Yes, Your Honor.
So the purpose also is to level the playing field for candidates so that the rich candidates cannot take advantage of their money to overwhelm the people with their quantity and size of propaganda. Is that right?
Yes, Your Honor.
Now, essentially, therefore, the law targets spending by the candidates and the political parties and their donors, since they're the ones who will really spend money for election.
Yes, Your Honor.
Now, the intention is not to control the spending by one person putting up a self-made poster in front of his house. Is that the target also? One person putting up a self-made poster in front of his house.
I would argue, Your Honor, that is still covered by the prohibition. Otherwise, there will be, what cannot be done directly can be done indirectly. All the candidate will have is to get a friend.
Well, it depends on the circumstance. If he's really the candidate doing it, spending for it, and really going around the law, then that's another thing. But here it's very clear that they're not doing it for a candidate paying them or as their supporter. If that is the case, I wonder why the law, the Fair Election Act, provides that the election propaganda, whether television, etc., is hereby allowed, and see this, for all, one, registered political parties, national, regional, sectoral parties, organizations participating under the party list elections, and second, for all bona fide candidates seeking national and local elective positions, subject to the limitation on authorized expenses of candidates and political parties. So that's what you're saying, huh? This law is about controlling the expenses of candidates and political parties. That's what the law itself says.
Yes, Your Honor.
So what does I say? If this, I myself, supposing I like Loren Legarda to be a senator, does the law punish me if I prepare a poster 2x4, not 2x3, 2x4, that says I like Loren Legarda in the Senate and put it under my window in front of my house? Will I go to jail for that?
My respectful answer, Your Honor, would be that would still be a violation.
Oh, well, if that is the case, why will the law say that it is limited to political parties and candidates? It says there. You point to me where it says private person is also covered.
Well, it was covered by the arguments this afternoon, Your Honor. But
well, by your interpretation now. Is that poster, should we not say that we have to look not only the size of a poster, because I can put up a poster selling a merchandise more than, let us say, 4x4, and that is not an election propaganda, it's an ordinary poster. Okay, so we have to look at the content. Is that right? We have to look at the content and find out what it is about. And also, we have to look at, as I said, whether that is a poster financed or prepared by a candidate or a political party. The real intention is to have many of them posted all over the places. So, in this case, is that the situation here? Is this poster before the church inspired by politicians who gave money to this church or donations to the church? Is this church a donor of political parties and candidates? I think the message here is clear. The message is that it wants to identify those who are for the RH bill and those who are for against it. So if you read it, and I am for those for RH bill, I'll I'll vote for those in that list that are voted for RH bill. The Team Patay, I'll vote for the Team Patay because I'm in favor of the RH bill. So this poster merely identifies the positions that some candidates have taken so that the voters can make some choice. Is that not right?
That can be right, Your Honor, but equally it can also be...
So that can be right. If it can be right, can you just say that it is a wrong poster? If it's a possibility that it is right?
Well, when I say, Your Honor, it can be right, but it can be equally right that the conclusion would
That's what I mean. So, well, in case of a doubt like this, if it can be both ways, You think we should send them to jail for it?
No, Your Honor, we're not saying you should send people to jail, but as said this afternoon, the Fair Election Act puts teeth to the legislative policy of limitation of posters. And that's a typical congressional enactment, Your Honor, which will have a penal clause. Otherwise, we can imagine what happens to all regulations if citizens can violate. So this is not a special provision.
But isolated expressions of preference by individuals is part of a freedom of speech. Is that not right?
I agree.
Is the intention of Congress here to prevent persons from expressing their preferences individually? As you said, if you put a sticker in my car, then that says, that's my statement. Even as you said, that was contributed by the candidate. So you see, putting such kind 4x4 down my windows, that's my expression of whom I prefer. So long as it's not commercial in number and I paid for it.
My response, Your Honor, will be precisely because there is a limitation. The fact that an individual, for example, a tycoon, a billionaire, can afford to bankroll a $1 billion campaign doesn't mean that if he can prove
That's different. That's different because if you can show, well, that will be a donor to a politician. We have many millionaires who donate money to politicians. But the diocese, the bishop of Bacolod, giving donation to those poor centers, by that poster, you call that political contribution?
My point, Your Honor, is a ₱1 billion political contribution is no different from a 4x4 handmade poster by a sole citizen, Your Honor. There is no difference.
When you said that what controls in this law is the spending. The big spending is the one that is being prevented here. But the Archbishop who spent, let us say, 1,000 pesos for that poster, is that big spending?
Well, the limit, Your Honor, of spending is in, for example, in national candidates, I believe it is 3 pesos per registered voter.
Yes, but
that is where the Congress drew the line. Provided the candidate doesn't go over that's where the Congress drew the line. Insofar as individual posters is concerned, the Congress drew the line at 2x3, regardless of whether it is made by a contributor or
by just one person.
By one person,
who has
Your Honor.
expressed a preference for a candidate. He will go to jail also.
Well, again,
that's a violation. He will go to jail.
If there is a violation, Your Honor.
I don't think we should send individual persons to jail who makes us kind of preference. Anyway,
that choice, point. If I may, Your Honor, rests in the Congress. If the Congress believes that the Fair Election Act should have no penal provision, that is a choice for the Congress to make,
If
Your
Congress
Honor.
believed that, it should have put that here. As I was reading the law, it applies only to political parties and candidates. You say that. Lawful election propaganda. Election propaganda is hereby allowed for all registered political parties, and it describes what is allowed them. So if it's not here, it is not allowed political parties and candidates. So the target really, as you said, big spending in election, leveling the field. Does not refer to expression by one individual out of 90 million voters who make a preference for one candidate.
Certainly, Your Honor, that defense, if there is a prosecution, that defense could be raised, Your Honor.
Oh, well. Now, I'll go to another point that you're raising. You said should have exhausted administrative remedies. That would have been fine, except that those guys from the Comelec were at the doorsteps of the church and wanted to pull down the posters. And then the Comelec also sent them a message that if you don't put it down within a certain period, then, please cause the immediate removal of said election propaganda material. Otherwise, we shall be constrained to file election offense case against you. They've made up their mind that he has committed a wrong. And they will file charges against them. So you mean to say you're going to go through administrative remedies and not come to this court when the freedom of speech is being threatened?
Well, Your Honor, the conclusion that led to the sending of the letter is that based on what is not contested, that the poster is beyond 2 by 3.
That's what I mean. They have made up their mind. So, if you say, so their mind and they're going to pull it down and you're given 3 days, meaning to say their judgment is executory.
Only in the
What
limit.
is the appeal there? The judgment is executory.
The under the rules, Your Honor, the Comelec has the summary power to bring it down if giving leeway to the agency in their best judgment, it is more than 2 by 3. Whether or not a perpetrator or whether or not a person is going to be charged still has to be left to the Comelec. And if they believe there shall be charged, there will still be notice and hearing, Your Honor.
Well,
because imagine, Your Honor, if there is no power like that, then politicians can just have all sorts of posters violating sizes, and then if the Comelec is not given the power to move administratively...
But the bishop here is not a candidate. It's not under the direct jurisdiction of the Comelec. Candidates, of course, are under direct control of because of the nature of their the office they're running for. But these are private citizens.
We agree, Your Honor, but our contention is that requirement is a secular requirement that applies to everybody, religious or not. Now, if there is a claim to carve out a exception to the 2 by 3 rule based on free exercise of religion, we concede that can be raised. But that has to follow certain procedures, Your Honor. Otherwise, again, anybody can now raise that in the name of my religion, or this is my dogma, then I am not bound by a regulation, a secular regulation put up by the state.
Thank you.
Thank you, Your Honor.
Justice De Castro.
I just want to pursue that line of questions propounded by Justice Abad. So are you saying that an isolated act of an individual property owner would come within the prohibition of the law?
It can, Your Honor.
It's an isolated act that Justice Abad mentioned. And a property owner who has money to spend, who has, say, 2,000 pesos to spend, would like to put up, say, an election poster on behalf of or in favor of a candidate. He spent his own money. He's not in conspiracy with a political party or with a candidate. It will not entail much money because it's just one incident. And yet, you think that will fall within the ambit of the law? Is that your position?
Our respectful answer, Your Honor, is yes, because then where do you draw the line? If it's 4 by 4, voluntary, in the home, what about if it is if a person owns a building, 30-story building, and he says, since I own this building and this is my money, and he puts up a 30-story poster, 12 candidates, and he says, this is my money, I can prove I did this willingly, voluntarily. Now, where do you draw the line, Your Honor?
That is not the example given, and I think the problem there is showing an attempt to circumvent the law, but that is not the example given. We're asking about an example which may happen to anyone. There are very few people who owns a building. Usually buildings are owned by corporation, not by individual person. We're speaking of an individual here, not big-time property owners. Now, assuming that you mentioned earlier that the test is not compelling governmental interest but reasonableness. How can you prove reasonableness if there's no connection with a governmental objective? Will you explain what you mean when you say that a regulation is reasonable without mentioning a governmental interest that is involved in that regulation?
Yes, Your Honor. Our submission is that the objective of the Constitution, which is to level the playing field during elections, is the objective, and the regulation to limit in this particular instance, type of communication, the limitation that in a poster, in order to achieve that objective of leveling the playing field, is to be implemented or effectuated by a limitation of 2/3, bears a reasonable relation to that objective, Your Honor.
The objective is the interest involved.
Yes, and as we said, Your Honor,
I think those are synonymous terms. You cannot say that the objective is not a governmental interest. The government has an interest in the holding of a free, honest, and fair election. So that is the interest of the government, and that is an objective. It's just one way of stating the interest involved. Now, what do you say about the ruling in Adyong, which says that the right to property may be subject to a greater degree of regulation when this right is joined by a liberty interest? The burden of justification is on the part of the government to show that there is an exceptionally convincing and irrefutable government interest involved. But you're saying that it's not for the government to, the burden is not on the government, but on one who attacks or challenges a law which impairs a constitutional right. But the rights involved here are three: the right to property, the freedom of expression, and three, the right to suffrage, which you cannot, which cannot be meaningful without the exercise of the right of expression.
Our answer would be, Your Honor, in the case of Adyong, there was no issue about the size of the decal. And here the government concedes that indeed the church of the diocese is private property. The only issue of the Comelec is, the size of the poster, the size of the tarpaulin.
But as it has been mentioned so many times earlier, the size may impair the ability to communicate, because the size may not be enough.
But as I keep saying also, Your Honor, that is a matter subject to evidence. And if the Congress said that 2/3 is enough, the burden is now, per this ruling of this Honorable Court in National Press Club, the burden is on the petitioners to show why 2/3 is not reasonable. If we concede that a limitation is reasonable, the only question is, where do you draw the line? Is 2/3 unconstitutional because of the visual impact, because you cannot squeeze so much content that in effect 2/3 impermissibly constricts content? But the petitioners have not said that. And if that is so, where do you draw the line? Is the constitutional line at 3/5, 6/10, and does it depend now on, whether a citizen can afford so, and provided there is no proof that he is in cahoots with a politician or with a political party, there is in effect no limit? Those are the issues raised, Your Honor.
It's not as simple as that. It's not only the size; it's the use of private property that is also involved here. And since it is the government that chose the size of 2/3, why should the burden be on the petitioners to show that is reasonable? It's up to the government to show.
Well, for that matter, Your Honor, if you go to the root of electoral reforms in terms of controlling spending, the argument could be that why should the government control anybody else's money? If the argument is, it's my money and therefore I can spend it, then the government cannot control. But that is the very foundation of the constitutional objective, to control spending and level the playing field. At least in our country, that is so, Your Honor. And certainly, for example, in other jurisdictions like the U.S., they have more respect for money in the electoral process. They do not have the limitations like we have on size of posters. Political corporations can give unlimited sums of money if it's your personal money. And in Osmeña versus Comelec, this honorable court said we have a different constitution, Your Honor.
Let's go back now to the test. How can you relate that isolated act of putting up a poster in one's home be connected with the regulation of spending by a candidate or by a political party when this act of an individual has no connection at all? It's a voluntary act born out of his own interest to see to it that the right people are voted upon.
Well,
it has no connection at all with the election campaign of a political party or a candidate. How can you relate this to that? Because you need to show, the government needs to show that this act, isolated act of a private citizen, will run afoul or will circumvent the law that is meant to achieve a particular objective, which is to regulate spending.
Well, as we said, Your Honor, in National Press Club, this court explained that under our Constitution, at least, it is the Constitution itself that puts that burden, a burden on speech, conceitedly. And the only question is the burden of a limited size 2x3 unconstitutional? If we concede that a burden can be made, then we say, Your Honor, whether it's 2x3 or bigger, or whether the Congress will carve out an exception to individuals who can prove that they have no relationship with political parties, again, that's for the Congress to enact, Your Honor, or to legislate. But as long as that stays in the books, and we are trying to show the reasonable relation, especially as a secular requirement, Your Honor, then that should be applied across the board. Otherwise, then you have all kinds of exceptions.
You apply that across the board, then it could be that you will be penalizing someone who may not have intentionally violated the law. My point is, if someone is sued on the ground that, as mentioned by Justice Abad, he posted an election material in his own home, and I think, don't you think the burden is on the government to show that he is in conspiracy with some political party or with a candidate to circumvent the law which puts a cap on election campaign funds,
well,
instead of just simply suing him for doing something which he has the right to do under the Constitution, which is an exercise of his freedom of expression and his right to use his property the way he wants it, to spend his own money the way he wants it. Wouldn't that be a violation of the constitutional right of this individual?
Respectfully, no, Your Honor. Precisely what has happened is if there's a 2x3 legislative rule. If a citizen happens to put out, in this case, 6x10, precisely the Comelec called your attention, please, you cannot do that because under the law, the maximum size is 2x3. And if the citizen, for example, says, I'm sorry, I did not realize that there is such a limitation, the Comelec can explain. And therefore, in the natural order of things, if a citizen concedes that indeed there is that requirement, then that citizen would most probably bring down that poster or order a poster but meets the maximum size, Your Honor.
There will be trouble if he does not want to.
No, Your Honor, a very respectful answer is there will be compliance with law.
But the individual believes strongly that the Comelec is trampling upon his constitutional rights and would resist the order to put down the poster, then that will now become a case.
Then you
before
will
the
put,
courts.
Your Honor, to a constitutional test, the act of Congress.
Thank you. If there are no further questions, we will... Justice Reyes.
The Diocese of Bacolod insists that it is merely expressing its religious views and beliefs concerning the sanctity of life and the integrity of the family when it endorsed certain anti-RH candidates. Indeed, the first tarpaulin carries the message, Ibasura RH law. Moreover, the otherwise oversized tarpaulins are posted on the walls of a private building, which is owned by the Diocese of Bacolod. If religious freedom or free exercise of religion is entitled to the highest priority and the amplest protections among human rights, according to Justice Fernando in Herman versus Barangan, 15 Iskra 514, by taking cognizance of the subject tarpaulins, is not the Comelec infringing upon the right of the Catholic Church to use its property for any religious purpose not contrary to law? And secondly, and more importantly, is not the Comelec violating the fundamental tenet of separations between the state, between the church and the state? Mr. Counsel.
Your Honor, please, our starting point will be, as this Honorable Court explained in the National Press Club case, is that, yes, indeed, speech is preferred, and yes, indeed, religion is preferred. But in the particular case of election reforms, the Constitution itself has imposed some limitation on speech. And therefore, since the burden imposed is one imposed by the Constitution itself, the only remaining question in a case such as this is not anymore whether there is a compelling state interest, because the compelling state interest to limit some speech is already provided for by the Constitution itself, Your Honor. So that is our starting point. So the general propositions about speech and religion being preferred freedoms are still good in other situations, but in the limited case of election reform, the power of the Comelec during the limited time of election to supervise sizes of tarpaulins is primary, Your Honor. And therefore, our respectful submission is, in that case, the Comelec, as authorized by the Constitution, as authorized by the Congress, is not violating the free exercise rights of the petitioner, Your Honor.
Including the separations between the church and the state.
Yes, Your Honor.
Thank you, Mr. Counsel.
Justice Leonen, preferably the last question.
Last question, only to be certain about the stipulations that you've made a while ago. Just one more question. Are you, is the Honorable Solicitor General willing to stipulate that the tarpaulins were not sponsored by a political party or by a candidate, but was at the behest of the Bishop of the Diocese of Bacolod?
Well, we have no knowledge, Your Honor, but out of respect, we're willing to stipulate, Your Honor.
Because it was the representation of the Bishop himself who said that on their honor, that it was only the Bishop of Bacolod.
Yes, Your Honor, we stipulate.
Solicitor General, you're excused.
Thank you, Your Honor.
The parties will be given the period of 10 days to submit simultaneously their memoranda. Now, since the 10th day will fall on April 29, which is Good Friday, we will March 29, which is Good Friday, we'll move it to April 1. Non-extendable. Okay. So, with this, the session is hereby adjourned.
All please rise.